Okay, so Chapter 11 is about real estate contracts. The first thing we're going to do is we're going to go over general concepts and laws, contract law, what you need to know for exam, what it's like in real life, and then we're going to learn about specifically how contracts are pertaining to real estate. Remember, when there's two rules that cover the same topic, the more restrictive rule will always prevail. And when it comes to a real estate law, remember, we have to follow not just contract law, but we also have to follow real estate licensing law. And in real estate licensing law, some things may be in a little conflict there when it comes to contracts. I'll be pointing out exactly so you know what I am talking about, okay?
All right.
So at the end of this chapter, you're going to be able to describe the essential elements of a valid contract, including the effects of statute of frauds, identify different types of contracts and issues that affect the validity of contracts. You're going to explain the various contracts used in the real estate business. So first, let's discuss what is a contract. Well, it's a voluntary agreement between two parties to perform some legal act, right? It has to be done as the free and voluntary act that both parties wish to engage in, right? So in Chapter 11, let me turn to the page here. So contract is defined as a voluntary agreement between legally competent parties, sound mind, legal age, right? To perform or refrain from performing some legal acts, supported by some sort of legal consideration. Consideration is a fancy word for compensation. In order for any contract to be legally valid, there has to be something of value that the parties give in exchange, right? So I want you guys to highlight that sentence, that a contract can be defined as a voluntary agreement between legally competent parties to perform or refrain from performing some legal act supported by legal consideration, and then right underneath that, compensation. Why do they call it consideration? Because there could be different forms of compensation. So in order for a contract to be valid to begin with, you have to have, there are 4 essential elements. Study them. This is a list you need to know for exam. You need to have competent parties, offer and accepted. Somebody needs to make an offer, somebody needs to accept it. There has to be some form of legal consideration given between the parties. And then the legality, the purpose of the contract or the object that the contract is based around has to be for a legal item or purpose, because you could have contracts to perform an act, so it has to be a legal act as well. Okay, these are the 4 essential elements of a valid contract to memorize. Now we'll go over each one of them in a little more detail. So on page 168, highlight the title, essential elements of a valid contract, and write the number 4 in front of it. And then there's a list there of the 4 essential elements. We'll just highlight the titles of each item in that list: competent parties, offer and acceptance, consideration, and legality of the object or purpose. See, in mine, I actually like to legality of object. See, they just put legality of object there. I like to call it legality of object or purpose. All right, so competent parties. What is a competent party? You got to be at least 18 years of age or older in New Jersey. You got to be a sound mind, can't be insane or Alzheimer's, dementia, and you have to be a sober adult. You can't be high or drunk. Otherwise, that contract's not going to be legally binding. Now, if you're under 18, a contract is considered voidable by the minor, but not by the adult. Could you ever be in a contract with a minor?
No.
Sure you can. You just can't enforce that contract against the minor. The minor can enforce the contract against the adults, but the adults cannot enforce the contract against the minor. Okay, so now you see I put this little point here, I added to my slideshows here, for exam purposes only, not in real life, because the laws have changed a couple years ago in New Jersey to protect minors. However, the exams have not yet been updated. I've been contacting the Real Estate Commission for ever since this law changed. But I guess it was falling on deaf ears, or I wasn't shouting loud enough. I don't know. I recently sent an email to many of the heads within the Real Estate Commission, as well as to PSI, the state's testing center, to try to find out some clarification on how instructors and schools and the exams are asking these questions, because not a single book that's published right now reflects the law accurately, has been updated. And the book we got is brand new, but it still hasn't been updated to reflect the law accurately. No book that I'm aware of that teaches real estate, and no instructor that I'm aware of even knows about this, or school for that matter, because nobody's reached out to the Real Estate Commission. But the laws have changed in the state of New Jersey. But for exams, they have not yet. So we're going to learn the illegal thing, what's illegal now, because that's considered correct on your state exam, because I just informed them about it, but they got to run it through their legal, and it's got to go through a whole process before they change the exams to reflect the correct answers. And then they got to send out a post on their website and yada, yada. So it's going to take a while. So I'm going to teach you real life versus what you need to know for exam here. So for exam purposes only, a minor, that's somebody who's under the age of 18, who is married, and you could only get married under the age of 18 with parental consent. Well, you used to be able to, you cannot no more. The law does not allow it any longer to protect minors, okay? In real life, the law does not allow it. But as far as exams are concerned, you are considered an adult if you are under 18 and are married. You can legally be involved in contracts that are enforceable against the minor, because a minor who is married is considered an adult and a competent party. Got that? And that's what the book still says too. The book says to enter into a binding contract in New Jersey, a person must be at least 18 years of age and of sound mind. But a married person under 18 is considered an adult. Now, in real life, they are not. But for exam purposes, they are. Everybody got me on that?
Yep.
Okay.
Yes.
So persons under 18 may enter into a valid contract. Okay, that's always the case and still is. But the contract is voidable by the minor. You cannot enforce a contract against the minor, because under no circumstances today is a minor considered an adult. But for exam purposes, when is a minor considered an adult?
When they're married.
When they're
When
married.
they're
They're
married.
married. Very good. Okay, so then that contract can be enforceable and only requires the married minor's signature, right? They don't need to have a legal guardian signing on their behalf for exam purposes, okay? Now, just so you know, they did update these laws. So a lot of child advocacy groups and such like that, there was a lot of this activity that was going on where
They were marrying minors.
they're protecting the minors, correct? Because you get a lot of immigration that's going on and such. We were seeing a huge influx of that during the last administration too. They were actually very, at the beginning of Trump's administration, you saw a lot of actions that he was doing, and did some legislation and passed some legislation too to protect minors from human trafficking. A lot of times you get people from different cultures where it's considered acceptable to marry somebody who's a child, the child brides. So we didn't want that to be of any influence here. So these advocacy groups change the laws throughout the United States. It's not just New Jersey.
What if they're emancipated?
You still can't be considered an adult. So I'm not sure exactly how that's going to work. I think they still need to have a legal guardian, even if they're emancipated. That just pretty much means they're divorced from their parents and that they can support themselves, right? So you get these child stars, they're making millions of dollars, but they're still minors. Okay, so to look out for the minor, they still need to have a legal guardian. All right, so competent parties. What's a competent party? At least 18 years of age or older and sane, sound mind, right? They're considered an adult for exam purposes if they're under 18 and married. Offer and acceptance. Offer and acceptance. I'm making you an offer, and then you have to accept it. If you don't accept it, we don't have a deal, right? This part is called mutual assent, where the parties are in agreement on all the terms of the contract. It's said that they've come to a meeting of the minds. Okay, so there's another term that we're going to be adding to our definition list. What is a meeting of the minds? It's when the parties are in agreement on all the terms of the contract. They not only are in agreement, they understand all the terms of the contract are stated and clearly understood by both parties to the contract. That's when you've come to a meeting of the minds, when you agree on all those terms as well. All right. Now, the definition for a meeting of the minds is a little bit different for school exam than it is for the state. State's just a little bit broader on it. It's when the parties are in agreement on all the terms. For school exam, it focuses a little bit more on the financial aspect of it, the finances. So it's when the parties are in agreement on price, down payment, and financing method. And that's on the slide, but not here in the book. Okay. Meeting of the minds will be in a later chapter, with much later chapter, I believe. All right, but we got it here. All right, so competent parties, offer and acceptance. And look, these four essential elements you can apply to any contract, even an employment agreement, right? In order to get a job, don't you got to be at least 18 years of age? I mean, you can get working papers at a lower age, to get a job, but you still you need your parents' permission in order to get working papers and work under 18, right?
Correct.
Somebody has to offer you the job and you need to accept it or deny it, right?
Mm-hmm.
You got to have some sort of a consideration. That's what they're going to pay you, right? Are you going to work for free? Right? So consideration is what the parties give or receive from each other in the exchange. The consideration is the entire purchase price. It's the entire value that's given in exchange. Okay. Now there's three legal forms of consideration. So once again, consideration is what the parties give or receive from each other. That could be legal tender. That's money or a mortgage loan. All right. Now I got a little note here that in New Jersey, a deed cannot be recorded in a public record unless the full purchase price is listed on the deed. Okay, you can't just put down $1 as a sales price, not unless it was a gift or it was refinanced, right? Okay, they're an exchange of something of value, goods or services. I will give you this in exchange for that, okay? That's an exchange of goods, right? Or services. I'm going to do this for you in exchange, you're going to pay me. That's what most people's jobs are, right? You're giving them labor in exchange for money, right? Or something else, you know.
Mhm.
And love and affection. No, 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 they're not talking about prostitution. When they say love and affection, they're talking about like a gift to a relative or a child, right? Their children, you know, if I have a kid, can I give them my house? Sure, I can. And then we just put down, we just have to have some sort of an certifying that in fact, that this is a gift. So you can't just put love and affection as the form of consideration. You have to also accompany it by a letter that states that it is a gift. Okay.
Okay.
So what are the three legal forms of consideration? Legal tender, exchange of something of value, and love and affection. And that's the one that people always seem to remember. All right. And lastly, legality of the object or purpose of the contract. It may not involve an illegal purpose or substance, the object of the contract, okay? So it cannot be against public policy. You cannot have a legally enforceable contract to kill somebody, for example. Why? Because murder's illegal, right? You cannot have a legally enforceable contract to sell crack cocaine. Why? Because it's illegal. It's an illegal substance, right?
Mhm.
All right, so what are the four essential elements of a valid contract?
Competent parties, offer and acceptance, consideration, legality of object.
There you go. All right, so under number 3, consideration, let's also highlight on the third line, consideration may consist of legal tender, exchange of value, or love and affection. Okay. And then after the 4 bullet points there, we're going to highlight that sentence. A valid contract may be oral or written. However, not for real estate. We're just talking general contract law here. I could have a contract with you to sell you my cell phone. Okay, that could be a verbal contract. It could be a verbal agreement, and they are acceptable verbal contracts, verbal agreements, if you can prove them. Right? Kind of harder to though, right? Without having it in writing. So that's why in real estate we have something called the parole evidence rule. Okay, well, actually, parole evidence rule not really as much pertaining to real estate. Pertains to people because you could have contracts that are verbal. The parole evidence rule states that the person who has it in writing has evidence. So therefore, the judge will throw out any case or claims that somebody who claims they have a verbal agreement, and with witnesses even, they'll throw that out in favor of the written contract because they have evidence, proof. Right? A little thing like proof can go a long way, right? I got it in writing versus what people are saying, right?
Right.
That's the parole evidence rule. You have evidence. What would your evidence be? In writing. There you go. So highlights the parole evidence rule, however, states that the written contract takes precedence over verbal, oral agreements or promises. Now, according to real estate commission rules, this is just a recap from like chapter 1, right? A real estate broker cannot be paid. They cannot earn a commission unless they have some sort of written authorization in writing from the person they're working for, right? So that written authorization is usually in the form of either a listing agreement or exclusive buyer agency agreement, right? It's signed by the customer or client. It applies to sale or lease contracts, anything. For us to get paid, any kind of contract, we have to have some sort of agreement in writing that we're working for this person and how much that commission is going to be. Okay, whether it's we're working with the seller or buyer, landlord or tenant. Now, something called the Statute of Frauds. Highlight Statute of Frauds states that all real estate contracts have to be in writing for sale. All real estate contracts for sale must be in writing. They must be.
Mhm.
Has to be. Now, leases, however, must be in writing if they're at least 3 years or more. Stop. That's if people are not working with a real estate agent. Because if they're working with a real estate agent, it has to always be in writing. Otherwise, we can't earn a commission on it, right? So anytime a real estate agent is working with somebody, it doesn't matter how long the lease is. It could be for 1 week. It must be in writing. This is, for example, if somebody's not using a real estate agent. This is just general contract law. If somebody's not using a real estate agent and they have a lease, leases do not need to be in writing unless they're 3 or more years. Okay. But if a real estate agent, but that's unwise to do. It's unwise for anybody to ever enter into a lease without it being in writing, right? Because now how you prove what all the terms of the lease were and how you went over the explanation with the person. You know, they later on, they're going to be like, oh, you never said that, you know? So it's always wise to get it in writing, but for exam purposes, leases longer than how long have to be in writing?
3.
3 years. And they can be recorded in the public record if they're 2 or more years. Okay. Why do we record any document in a public record? It's not on this slide, and it's not in the book here. You guys recall why we record documents in the public record?
Just so if someone ever did a title search, they're able to find out information in regards to the property.
Well, so what's the purpose of that? If they do a title search, well, why are we putting it in the? Why does anybody ever attach anything to the ownership documents in the public record?
It's proof.
To put the world on notice of our interest in that property. Okay. So why do lenders record their liens in the public record? To put the world on notice that they're owed money and to reserve their lien repayment order, right? If you got a long-term lease, you want to put the world on notice that you have a long-term interest in this property. So let me give you an example. There's a guy over there in the ShopRite in Edison. If anybody's familiar with that on Route 1 over there. That ShopRite in Edison, that entire shopping center is being rented by one guy. And he has an agreement with the owner that he can sublet it. So all those units there are subleased. So you think that guy, he got a really long-term lease there because he's signing leases with ShopRite and every single store in that strip mall there. It's kind of like he gets out of it. What does he get out of it? Well, the landlord doesn't have to worry about any vacancies. He gets paid the rent all the time and all the taxes and maintenance and all that's all taken care of. Those charges are all paid. So what does this guy get that's, or this other guy get that's renting all those units? Well, he acts like a landlord without actually owning real estate. Right? He just got a lease. And he has an agreement with the owner. He's allowed to sublet it, all those units. So he just marks them up and makes money off of it. So you think it's expensive to rent in there?
Yep.
Probably, yeah. Actually, I know it is. I went to go find out to rent one of the units in there from that guy. Wants a lot of dough. Okay, so it's extremely risky to rely on oral agreements, verbal contracts for leases. They should always be in writing. But when real estate agents involved, it always has to be in writing. Okay?
Victor.
Yes, sir.
So, quick question. I think it's pretty clear what you're saying, but I just want to just ask about a potential situation. So,
Sure.
You have two. A contract is made. All the terms of the contract are in the contract, and one party does not sign.
It ain't
Right,
a contract. If only
It's not
one
a
party
contract.
signed it, you don't have a contract. It has to be signed, has to be fully executed by both parties.
even though it was orally spoken and both parties started to act on the terms of the contract, it has
Well,
to be signed.
the signed contract don't mean squat because it's not signed by everybody. If you go to
Got it.
court with
Got
that,
it.
they're going to
Okay,
throw it in your
okay.
face. The judges
Okay.
throw it
Okay.
out. You know, that you can't use that as evidence of the agreed upon terms.
Got it. Got it.
Okay.
Got it. Got it.
Now,
Thank you.
and
Yeah.
having the verbal contract, on the other hand, how are you going to prove what all the terms are? Yeah.
Got it. Got it.
That's why
Got
it's
it.
important to get it in writing, but when it is in writing, it needs to be signed by
It
everyone.
needs to be signed. Excellent. Got it. Thank
And
you.
don't ever leave blank lines on contracts.
Got it.
All right, so real estate licensees, we always follow licensing law, the real estate law, Title 45, Chapter 15, right? And the rec rules, the rules and regulations of the called the Administrative Code, or Title 11, Chapter 5, right? Which requires licensees to always have our contracts in writing. We must never have verbal agreements. Got that? So there's two laws there. One is general contract law. It states all real estate contracts got to be in writing, except for leases, unless they're 3 or more years. However, if a real estate agent is involved, doesn't matter how long it is, it still needs to be in writing. But for exam purposes, when does a lease have to be in writing?
If it's
3 or more years,
3 or more years. And when can it be recorded in a public record?
that's longer than
2 or more. We should write that at the end of that paragraph under Statute of Frauds, which we highlighted. Statute of Frauds, if you didn't highlight it now, Statutes of Frauds states that a contract for sale of real estate and any lease for more than 3 years must be in writing and signed to be enforceable. And then right at the end of that paragraph there, leases longer than 2 years may be recorded, because it's somewhere else in this book. But I like to keep the stuff together because that's relevant information just to study together like that. Or snap a picture of this slide. Okay. The whole section underneath that talks about exceptions, we're not even going to read that because that just talks about, that the contracts don't have to be in writing, but it's extremely risky to do that. And it's the whole thing that we just spoke about. Okay. Now, types of contracts, which we're going to go over now. Contracts can be, these are some of the terms we're going to be going over. They could be express or implied, unilateral or bilateral, executory or executed, valid, unenforceable, voidable, or void. Now let's go and find out what those things mean. So, an express contract. Well, let me ask you a question. How do you express yourself usually? I mean, sure, you could do it in dance, but not when we're talking about contracts, right? You're going to be doing it in words, right? So an express contract is one that has been fully stated in words. And that is, even though technically they could be verbal, but for real estate, we know they cannot. So it's going to be in writing, right? So an express contract is laid out in words. It leaves nothing to interpretation. There's no guessing about anything because you fully spelled out all of its terms and the other parties in agreement to them before they signed it. Right? Whereas an implied contract is expressed by one's actions rather than their words. And then I give you an example here, an example of an implied contract. The lease expires and the tenant didn't sign a new lease, but the tenant gives the landlord the check for the next month's rent. The landlord accepting that rent payment for that next month, the actions of them just grabbing that check and accepting the check creates an implied contract that they're fine with the tenant staying there and being there a month-to-month tenant now. Now, the only issue with that is, what are all the terms of that lease? Does it go by what the previous written lease was, all those terms? See, it leaves some stuff to interpretation. Right? This is why you should always put it verbal, you should always have it in writing with words. All right. Now, here's another example of an implied contract. If somebody's in foreclosure, you know, let's just say you fall behind on your mortgage payments. The bank is going to be doing all their collection calls. Now, at some point, those calls will stop. And even if you call the bank to make a payment over the phone, they won't even accept your payment anymore. Now you know you're in foreclosure. They can't accept the payment unless you pay everything that you're behind, including all the penalties, everything. The reason being is if they do accept any kind of a payment from you, and then you actually show up to the foreclosure suit in court, you could say to the judge, but Your Honor, they accepted a payment from me. I thought we had an agreement that I could get caught up paying little here and there whenever I could.
Oh, no, you about to-
That'll raise a judge's eyebrow. He'll be like, what do you mean the bank accepted a payment from you? Because banks are not supposed to accept a payment because it creates this possibility in my head here that maybe you did have some kind of a verbal agreement. Otherwise, why would they be accepting a payment from you? They would just be trying to get you out, right? So that's that big question mark, that big what if scenario. So it creates the actions of the bank accepting any kind of a payment from somebody when you're in foreclosure now creates this implied contract that you had some sort of a possible agreement in place. Okay, so when that doubt is put into place, as long as they could prove that a payment was made after it was in foreclosure, the judge is going to kick that foreclosure suit out. Tell that bank to start all over again. Now, unilateral contract versus a bilateral contract. Well, let's first do some highlighting on page 169 at the top of the page. Let's highlight an express contract. The parties state the terms and show their intentions in words. And then on the following line, we're going to highlight an implied contract is demonstrated by their acts and conduct. Okay, so it's demonstrated by their acts and conduct rather than their words. Okay, now unilateral versus bilateral. I switched them around on this slide. I like to teach unilateral first. Unilateral contract is a one-sided agreement or promise. Only uni meaning one, right? Uni is one. A unilateral contract is a one-sided agreement where one party is obligated to perform some act, but only if the other party does. So that means that the other party has an option to do something or not, right? So unilateral contracts are typically have options in them. And any contract that has an option in it is referred to as an option agreement. We as real estate agents can never prepare option contracts, okay? Only an attorney can. For example, lease with an option to buy, you know, the tenant is leasing the property from the landlord and they have an option to purchase it at a pre-negotiated sales price. And they have a pre-negotiated deadline that they need to give the owner if they're going to buy or not. Now, is that tenant required to purchase it if they have a lease with an option to buy?
No.
No, they are not. However, if they do exercise their option to buy, is the landlord obligated to sell it at the pre-agreed upon sales price?
Yes.
Yes. Okay. So a unilateral contract is a one-sided agreement where one party's required to do something, but only if the other party acts. Okay.
I have a question.
Yes.
Sorry. So would this be like, I will buy the house if you do these repairs on the house? Is
No,
that-
there's that you're adding another condition to it. Okay. I mean, I guess so. It could be, but that's like a lease with an option, but only if there's another option. You're adding another layer of options to it. Whatever that is that you're getting into right now, that's another option. So
Oh, okay.
let's just stick to it. Let's keep it simple. You're renting. I'm the landlord, and you're going to rent the property from me, right? And you're like, this house is really nice. I'm just not ready to buy just yet. But I want to see if I could save up money and get a loan, see if I could qualify, because I can't really qualify for a loan just yet. But can we do a lease with an option to buy where I'll lease it from you? And if any time during this, before the lease term expires or before a certain date occurs, that I have an option to buy this property from you at whatever agreed upon price that we agree on. So are you obligated to purchase from me now?
No.
No, you're renting from me, but you're not obligated to buy from me. You have an option to. But you have to exercise that option. You have to decide whether you're going to buy by a certain deadline that will be stated in the contract. Okay, this isn't forever. We're going to state a deadline where you have the option to buy by. And we would have pre-negotiated in advance what that purchase price would be. And what all the terms of the contract would be all specified in advance and agreed upon in advance. But you don't have to abide by it unless you decide that you want to go through with it or not. And if you decide you want to go through with it, me as the landlord, I'm obligated to sell it to you at those terms that I've agreed to already.
But if he gets
So real estate agents can never prepare these contracts. Only attorneys can, because they could get kind of complicated. Because the lease is one contract in itself, and the option to buy is a separate agreement, isn't it?
Yes.
They may put it in one document, but they're two separate agreements. So we know the lease contract, how it works, right? We got all the terms. We're competent parties. We're giving an offer to rent. And then the consideration is you're going to pay me the rent. And then the option itself, what's given in exchange? What's the value that's given in exchange for that? I'm giving you the option to buy my house at a pre-negotiated price. And I'm reserving it just for you right now. What do I get out of holding that option out there for you? You got to give me something of value. Maybe you're paying extra rent. Maybe you're paying me an extra upfront fee for that option. But what happens if you don't end up exercising your option to purchase? What happens to that extra money that I was paid? Do you get it back? Depends how the attorney wrote up that contract. See, that's why you got to have an attorney do this, because what would be legal is another question with that. All right. Now, it's an easy way to find out if a contract is unilateral or not, simply by applying this statement as your litmus test to your situation. I will do this if you will do that. If you will do that. If you could apply this statement to your situation, it is a unilateral contract because somebody has an option to do something. If you will do that. That means that they don't have to, right? Now, on the other hand, a bilateral contract, both parties promise to do something and are obligated to do something. I will do this and you will do that is the litmus test to determine if it is a bilateral contract. So bilateral contract, bi meaning two, both parties are required to do something. Unilateral, uni meaning one, only one party is obligated to do something, the other has an option to. Okay. Awesome. All right. So let's go and highlight bilateral contract. Both parties promise to do something. On the second line there under bilateral unilateral contracts. Bilateral contract, both parties promise to do something, and then highlight the last line in that paragraph. I will do, or underline it, I will do this and you will do that. That's your litmus test there. And then the explanation of a unilateral contract, they do it kind of wordy way here. What did I tell you is a unilateral contract? One party's required to do something, but only if the other party acts. Right? But they have an option to. That's an easy explanation to understand. Here's their explanation. We'll still highlight it, but you got to follow the bouncing ball here, okay? Highlight a unilateral contract is a one-sided agreement whereby one party makes a promise to induce a second party to do something. The second party is not legally obligated to act. However, if the second party does comply, the first party is obligated to keep the promise. Follow the bouncing ball on that one. All right. And right at the end of that paragraph or above it, must be prepared by attorneys.
So both unilateral and bilateral have to be prepared by an attorney.
No, only the unilateral.
Oh, okay.
You're a real estate agent. You could prepare a lease. You could prepare a sales contract on 1 to 4 family homes or 1 to 4 family properties and single residential buildable lots, right? But we cannot prepare lease with options to buy because there's an option there. Option agreements have to be prepared by attorneys. Option contracts must be prepared by attorneys. All right. Executed and executory, nothing really to highlight there. It's just for us, but we do need to understand the word executed because we do throw it around in everyday real estate. Okay. Executed just means, hey, did your client execute the contract? I'm asking if they signed it. So we have a fully executed contract now. I'm asking if the contract has been signed by everybody. Okay. Who is it? Somebody asked me before about a contract being signed by one of the parties, okay? Well, that's not been fully executed. It's only been executed by one of the parties. You see how I'm throwing the word around in the contract, in the sentences? Depends on how you use it in a sentence, okay? Has your client executed the contract? What am I asking?
They sign the contract.
Have they signed the contract? So now we have a fully executed contract. Has it been signed by everybody? That's all I'm asking. Okay, so it depends on how it's been used. Now the term fully executed can have 2 meanings to it. It could mean it's been signed, a contract that's been signed by everybody, or a contract where all of its terms have been fully carried out, meaning that there's nothing left to do. The contract had been fully performed. That type of contract is now checking more of the status. That's when the word fully executed is checking more the status of the contract. Now the term executory, it ends in T-O-R-Y, tory means it's in progress still. So it means that if a contract's in executory status, that means all the terms of it have not been fulfilled yet. So has your client executed the contract? Somebody ask me, role play with me.
Sign the contract.
So I'm asking, so has your client signed the contract? Correct. So do we have a fully executed contract now? What am I asking?
Have all the parties signed it.
I'm asking if all the parties signed it.
Yeah.
Now, what status is that contract currently in now once all the parties have signed it?
Fully executed.
It's in executory status. It's been fully executed, meaning it's signed by everybody, but the contract itself now, and what status is it? it's not been fully executed yet. We've only had it signed by everybody. All the terms within the contract have not been fully performed or carried out yet. Now we got to do everything that the contract requires us to do. So that contract is now in executory status. And once we do everything the contract requires of us to do, it's been fully executed.
Okay.
All right, don't sweat it. You're not going to get anything on exam for it. If you do, it'll probably be pertaining to it just being signed. Okay, this term executory, I've never heard it used in my life. Okay, so I've never seen this on exam either. This executory crap, I've never seen that on exam. So don't sweat it. But the term executed and fully executed, I'm just giving you guys an explanation. All right. So nothing really to highlight there. All right, so contracts can be valid, voidable, unenforceable, or void. We're going to highlight some stuff here in the book, but really just study this slide. This slide gives you a good, clear explanation of these four statuses of a contract, but also has two additional terms in here that we're going to learn about as well. So this is actually a pretty good slide just to study from too. Now, what is a valid contract? It's one that meets all the legal requirements. It has all the four essential elements, right? Competent parties, offer and acceptance, consideration, and legality of the object or purpose of the contract. Avoidable contract is one that seems on the surface to be valid. However, one of the parties can disaffirm or cancel the contract. An example of a voidable contract would be a contract with a minor, right? They weren't a competent party to sign the contract in the first place. You can sign a contract with a minor, and if that's the case, can the minor hold the adult responsible to their terms for the contract? Can they hold the adult liable to the contract?
Yes.
They can.
Yes.
But the adult cannot hold the minor to the terms of the contract if the minor simply says, I want out. But what if the minor is married, for exam purposes only?
Then yes, they can if they're married.
Then it can be enforced against the minor, because the minor that is married is considered an adult for exam purposes only for now, right? So you see why I gave you that full explanation there? It's important in real life for us to understand how it works, but also on these exams. Unfortunately, exams are wrong, and this is beyond my control, so I have to teach you what it still is, okay? All right, now here's another example of a voidable contract. One of the people who signed the contract, only one of them was high or drunk when they signed it.
It doesn't count.
No. Or they had Alzheimer's or dementia.
Nope.
Or they were insane.
They
Nope.
are not competent.
They're not a competent party to sign it. Correct. Actually, I could fit that in there. I should give that as another example, shouldn't I? What slide is that? Yeah, four already. All right. So we could also add on there another example.
Alzheimer's.
One party, not of sound mind. Yeah. It could be Alzheimer's, dementia, they're insane, or some other mental disease or defect is affecting them. Right. Now, when somebody's under undue influence or duress, that one party, that's another example, that one party can cancel the contract, because undue influence means that they were taken advantage of in some way. Duress means they were forced to sign the contract. Maybe you intimidated them to, right? Maybe they felt like they had no other way, or you really had some sort of a serious influence over them, you know? That's duress. Undue influence, they took advantage of you. Duress, they forced you to. You know, you're gonna sign it or I'm gonna break your fingers, you know. There's an example. All right. Unenforceable contract also seems on the surface to be valid. However, neither party can sue to forced performance, perhaps because neither party was a competent party at the time. Just an example, spitballing ideas. Maybe you signed a contract with your buddy that you were going to buy his house, and you guys were both drunk. Yeah, man, I want to buy your house. Oh, yeah, I'll sell it to you. All right. Now, when you guys sober up, is that contract still valid?
No.
It is if you both want to be in the contract still. But then it's referred to as being valid between the parties, because neither party can sue to force performance. It's not enforceable. But if both parties wish to go through and carry out the terms of the contract, they can do so, and then it would be considered valid. But if one party breaches the contract, well, you can't sue them because you were both drunk when you signed it to begin with. So what's the best option there? When you both sober up, sign a contract, right? When you're sober. All right. Now, avoid contract is a contradictory term because avoid contract isn't a contract at all. It's one that has either been canceled already or one that's missing the essential terms required for it to be valid and enforceable. Okay. So usually they'll give you on exam, you need to know an example of a voidable contract, and usually they give you the example with a minor. But I don't know, they've been changing these exams around a bit. It may be one of these other options too, but I gave you a couple examples here. I gave you 4 different examples. All right. All right, so what's the last thing we highlighted? Okay, let's go down to the bottom of the page, 169, and highlight a voidable contract is one that seems on the surface to be valid, but may be rescinded or disaffirmed by one of the parties. For example, a contract entered into with a minor is usually voidable. And then we'll turn the page.
Is that the only thing we highlighted in validity of contracts?
Yep.
Okay, thank you.
And then undue influence or duress on the next page. I just put a little asterisk next to it, a little star next to it, just so that we have the understanding, you know, undue influence, being taken advantage of. I give you a little write-up here because it is kind of important. You should use extreme caution when you're dealing with elderly people. Now, don't automatically assume because somebody's old that their cheese is sliding off their cracker. You know, their brain is not all there. Have respect for people. All right. But you need to pay attention because it's difficult to tell if somebody's of sound mind or not. Right. You don't know if somebody's is bipolar or if they're insane or if they have Alzheimer's or dementia. Hell, sometimes you may not even know if somebody's high or drunk, right? Depending on how high or drunk they are, right? But just by looking at them. So you gotta take certain mental cues from them, you know, when they're, you know, how are they responding to your questions? Are they searching for their words? You got to try to just do your best, you know. Now, when dealing with elderly people, what I've come to do now, I make it a habit, is I ask them questions. I'll just say, so is there anybody else that needs to be signing contracts with us here today, or is it just you? Now, I mean, I've come across elderly people before that were pretty sharp, and they were like, "What are you trying to say? I'm not of sound mind there," or you think I got Alzheimer's or something? You know, I had one lady that caught that, you know, And I was like, no, 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 no. I just wanted to make sure there wasn't anybody else that was like an owner that needed to sign the contracts. You know, I already knew. I was just trying to pedal my way out of it a little bit. You know, you don't want to insult them either, you know, but that one's an easy way to that one's an easy one you could back out of. But the reason why I ask it is sometimes you try to stir something in people. Because look, I've had a listing one time that I dealt with this older lady. She was sharp as a tack, you know, and I got the listing from her, you know, but she was interviewing with a bunch of agents. And then a couple of days after I get the listing, I get a call from some lady claiming to be her daughter. Says, listen, I went to my mom's house. She had all this paperwork from all these realtors. And then she told me that she listed her property for sale with you. And she said, my mom's not selling her property. She's like, my mom's got dementia and, you know, I'm her legal guardian, you know, so you gotta take down that listing. So what should I do?
Take down the listing.
Should I? At this point, I have no idea who this lady is that's calling me on the other line.
Well, I mean, get proof, obviously.
Well, it's not that obvious. I want to make it a point, okay?
Oh.
Because it's not always that obvious to everybody. So I'm going to play Captain Obvious here, okay? So you want to make sure that I mean, look, that person could legitimately be her daughter, but is she the legal guardian? You know, maybe it's just the daughter that doesn't want mom to sell the house because she don't think mom's going to be living much longer, and she don't want mom to sell her inheritance, you know. I don't know. So she needs to come in and bring in her legal paperwork. She should have some kind of paperwork from the court that states that, right? And so she did. And then I had her sign the release of the listing documents so that I could cancel the listing. All right. Otherwise, I can't just change the status of a listing in an MLS because the MLS will fine me if I don't. I need paperwork. I need the owner's authorization. So even if I'm pulling a listing or canceling a listing, I need some sort of paperwork. And here's an example. Pull it up in the Garden State MLS real quick. Let me look at their paperwork.
Victor, I have a question about that.
Sure, sure.
Like, there was a situation, well, isn't there a expiration on power of attorney? The reason I'm asking that is because my mom went through the same thing with my grandmother, and they wouldn't accept documentation because the power of attorney was too old and they wanted something more updated. Does that apply with that, or?
It shouldn't if they're not of sound mind.
Okay.
You know, if they're not of sound mind and you're their legal guardian, there should be no expiration on that because they're not going to be getting any better.
Right. No, I'm just wondering if there's like, you know, like
but
how it works.
It depends on how that power of attorney, who wrote it, when it was, who wrote it and what it says in it, you know, is ultimately what you really need to check, because I don't want to say definitively. I'm just assuming, and you know, but you got to know, we got to remember, don't assume anything, because what happens when you assume, you make an ass out of you and me, right?
Right.
So yeah, you got to read it unless it says something in there specifically that it expires.
Okay.
I would assume that a power of attorney for somebody who's not of sound mind would not expire.
Right.
All right, so I'm on the Garden State MLS's website here now. Let me see their forms, contracts, and listing input sheets. They have one here for a change form. So anytime you're going to change the status of a listing, remove the listing, pull it, or what have you, you got to fill out a change form. You can't just go in there and change the status. You have to go change it and say that you're canceling it or withdrawing the listing and what the withdrawal date is. And then you got to get that owner to sign it, owner's signature. See that down the bottom? Got to get them to sign it. Or if it's not the owner, but it's this person that's got the legal guardian, you should have that legal guardianship paperwork too. You know, and then I'll just send this to the MLS. You know, if they catch it that there's somebody different signature than the owner on there, then I'll let them know what the situation is, but they don't need to get all the legal paperwork, okay? Unless they ask for it specifically. All right. So, but look, my strategy, the way I do things like that, it actually worked out for me pretty good one time. Look, you could get a person with Alzheimer's, and you know they are sharp as a tack, but they don't know what year it is. You know, some people it's just it's minor. You know, they just like hunt for words a little bit. You know, or you may notice a little shake in the hands. But you know, a lot of old people, they shake. It could be something else, the reason why they shake. You know, searching for their words all the time. Those could all be cues, but not necessarily. They could be very minor like that if they got Alzheimer's, or it can be drastic. You know, it could be that they're staring at a wall. You know, you talk to them and they don't answer you. You know, they could be. You know, it's like a living coma. You know, or you could get people who they're walking around all day, but they don't remember anybody's name. You know, you could see some of these Alzheimer's commercials on TV for the beginning of Alzheimer's or dementia or what have you. There's certain stages where people even see shadows of beings that were there, like maybe a dog or you as a child, you know, and then, oh, weren't you just here a minute ago? You know, and, you know, their mind is playing games on them. You know, other people are lucid. They know that you're there. They just don't know who the hell you are. They forgot that you're their son or daughter, right? Or they know who you are, but they forgot what year it is. You know, so you just got to use your best judgment and try to look for signs and cues. I had another instance where I dealt with an elderly gentleman, and I asked him that question: is there anybody that needs to be signing contracts with us here today? And he was like, oh, thank you for reminding me. You know, and this is a guy, he had a little bit of the shakes too. He said, oh, thanks for reminding me. But the guy was really sharp. You know, he took me around the house. He was talking to me, but he totally forgot his son needs to sign contracts with him because his son has power of attorney now. You know, so his son, he's like, oh, let me just get him on the phone. My son, he's right around the corner. He needs to come over. He needs to sign too. He's like, you know how it is. He's like, you know, when they're young, you take care of them. He's like, you get older and then they take care of you. I know exactly what he was talking about, you know. So his son came on over. He had his power of attorney with him. You know, I had all that info, did all the paperwork. We listed it. They did want to sell it, which is good. The case with the older lady, however, that I had, you know, they withdrew the listing. The daughter was the power of attorney and did not want to sell it. Okay. So you just got to be careful. It's not a listing that you have any control over. If somebody does have a mental disease or defect and they want to pull you can't have a legally enforceable contract with somebody who's not of sound mind, is the bottom line. Okay. Yeah. Now, duress. Duress, once again, you can't use force, threats, or intimidation or bribery. Undue influence. You also should be careful with people who are maybe in the hospital or on their deathbed. You know, be careful about. I wouldn't have anybody sign a contract in the hospital. I would let their attorney deal with that. I'm not going to be extracting signatures from somebody in a hospital. That's like prime real estate for a lawsuit later on down the road. Look at this bottom feeding realtor, so hungry to sell that property to earn a commission. They get the person to sign a contract when they were scared that they were going to die. Right? Can that contract be canceled later? Possibly, you know? So undue influence and duress, that's what those things are. Now, here's some additional contractual issues. All right, we have dates in contracts. Now, these dates to perform certain things, whether it's doing an inspection, the closing date, when the buyer needs to produce a mortgage commitment letter from their lender by, that's a letter where their lender is committing to giving them the loan to buy that property. Well, these dates are merely guidelines. Courts have held that dates in contracts are merely guidelines. And if somebody misses a date in a contract to do something, they are not considered in breach of contract because those dates are just merely guidelines for you to follow. However, sometimes these dates, we want to have strict deadlines to them. And if that's the case, sometimes we would use this term here, which we should leave its use strictly to attorneys to use. It's called time is of the essence, meaning it's very important. And anybody who does not perform on time is in breach of contract. So let's back it up to the beginning of this slide here. Breach of contract is when somebody breaks the contract without having a good legal excuse to do so. Then they're in violation of the contract and they can be sued. They can be held financially liable to the other party. All right, so time is of the essence. This you need to know, so we're going to highlight it in the book. This means that the contract must be performed within the time limits specified, and any party who has not performed on time is guilty of breach of contract. Okay, so this is a strict deadline that must be met in contracts. However, keep in mind that I think the book even refers to it this way. This term should be left strictly to attorneys to use, and be warned, it is a double-edged sword. What does that mean? It means it cuts both ways. So let's just say that we're looking at the contract and the buyer did not produce the mortgage commitment letter yet. And we need that from them. We need to know if the buyer is going to be able to get the loan to close on the property or not. Because if they're not, let's cancel this contract so that we can put the property back on the market and get another buyer who can. So they put a date in the contract. The buyer's agent puts a date in the contract when the buyer is going to produce this mortgage commitment letter by, and that's usually about 30 days after the attorney review. Okay. We'll go over what's required to get that mortgage commitment letter a little bit later in this part. I'm not sure if it's in this chapter or the mortgage chapter is coming up, but I'll explain it in this chapter still. So let's just say that mortgage commitment letter date comes and goes, and the buyer's agent never sent over a copy of that commitment letter to the listing agent. So I'm the listing agent. I call you up as the buyer's agent. I'm like, hey, what's up with the commitment letter? That date's come and gone that you put in the contract, and we didn't get it yet. Is there a problem? It may have slipped your mind to get it from the mortgage rep. Or you may have gotten it, but you forgot to send it over. If that's the case, send it over to me. Otherwise, a lot of times buyer's agents start making up excuses. Let me check out. Let me give a call to the mortgage rep and see what's going on. I forgot to call. I forgot to follow up with them. So you call up. Okay, we're gonna need a few more days for them to get that to us. Something is just missing that they're still waiting on. A few days passes. Didn't hear from you. You got that mortgage commitment letter yet or not? Just need a couple more days. And this keeps going on and on. After a while, I'm starting to get the feeling that you may be jerking us around here. You may be having a problem getting that commitment letter. That buyer may be having a problem getting the commitment letter. And you're just not being straight with us and letting us know. So I'm going to go to the seller's attorney now as the listing agent. And I'm gonna say, hey, listen, I don't know what's going on with this buyer here. I don't know if they're just jerking us around or if it's legitimate reasons, but they keep delaying and delaying, and I still don't have the mortgage commitment letter by from them. So I need you to issue a time of the essence order. So that attorney now is going to issue this letter, a time of the essence letter to the other side, and says, for example, you have so many days to produce the mortgage commitment letter by. And if you do not produce it by them, that's it. Contract is automatically dead. Nobody needs to send any additional letters, nothing. They're going to give a date and time that mortgage commitment letter needs to be produced by. And if it's not sent over, we're not calling again. If you don't send it over, contract is automatically killed. Okay. Now let's say that date comes and the time goes. Contract is automatically killed, right? What happens if the next morning they get it? Contract's dead already. It was killed. Can it be pieced back together?
Yes.
Yes,
Sure. But the other side doesn't have to agree to it.
right.
It could be a new contract.
They may want to do some renegotiations now. Hey, your side killed
Yeah.
it. We're not in breach of contract. You killed the contract saying that we were in breach because we did not produce the mortgage or that's not in breach. That's actually one of the things of the contract. If you can't produce the mortgage commitment, you're not considered in breach if you can't get the loan. So they can't hold you in breach of contract, but that means that they killed it though. The listing agency killed it. Now the buyer can now renegotiate the terms of the contract a little bit, say like, oh, you know, we're still here. We still want to buy. And now we got this commitment letter here. But you know what? There were some things that you guys weren't agreeing to before. We want you to agree to them now. They got a couple more cards in their hand now. Yeah, it's either that or you list the property back on the market for sale and hope that you find another buyer at that price. Right? So you got to be careful when using this term. Time is of the essence. All right. So a strict deadline that must be met, that's in the contract. Time is of the essence. Add that to your definition list. We already highlighted it. Moving on. So now we're going to talk a little bit about performance of contracts, dates or guidelines merely to follow. We already spoke about that. Different ways that a contract can be discharged. We already spoke about default or breach of contract. And what statute of limitations, or what that term means, and what statute of limitations are for real estate contracts in New Jersey. Before we do, let's talk about assignment and novation. Okay, so assignment is when one party in a contract assigns their contractual obligations or duties to somebody else. Now, an example of this would be, say that I'm renting a property from you. And I find a property that I want to buy. And you won't let me out of the lease because I got a written lease with you. You don't have to because I have a contractual obligation with you. But what if I'm able to find another renter? Will you allow me to sublease to them? Because you don't want to let me off the hook. You're like, well, I signed the contract with you. If you find another renter, that's fine. Let them pay the rent. And as long as they follow the lease terms. But if they don't, I want to be able to chase after you still too. Is that fair enough? Well, that's assignment. See, most contracts, most lease contracts state that they cannot be subleased or they cannot be assigned. Okay. But if the landlord does allow me to find another tenant for my unit, if they don't pay the rent, am I still obligated to pay it?
Yes.
Yes, I am. All right. So that's what assignment is. You assign your obligations or duties to someone else, but you always hold primary liability. You're never relieved of your obligations. Okay. Now, isn't there a way that it can be so that somebody else can take over and I am relieved of my contractual obligations? Yes, it's called novation. So novation is either replacing the old lease with a brand new one so that the old lease has no legal force to it, or it's replacing a person named in a contract with someone else so that the old person, the original person named in the contract, has no further liability. Okay, so you could either replace the contract or you could replace the person named in the contract. If you're replacing the person named in the contract, it's technically called novation of the parties. Okay, but either way, it's novation. So what is novation? It's substituting an old contract with a new one. So the original contract has no further legal force. It's not enforceable. Okay, this term is usually on exam. So let's highlight the awful definition that they have in the book for it. Novation in the third paragraph, you guys see that under assignment and novation? Bottom of page 170. We're going to highlight novation in bold, or the substitution of a new contract for an existing agreement. That is weirdly written that it sounds like it doesn't make sense. Bless you. So
Thank you.
novation, you're actually you're replacing the old contract with a new one. Okay, their wording's a little bit weird. You may want to snap a picture of this definition. A little bit easier to understand. Okay, now contract, the discharge of a contract. Here's a couple ways. There's nothing to highlight in here, but I'm going to go over all these ways that a contract can be discharged. It's just important for you to know the processes, the different things that could happen in contracts, okay? So we just need to have this basic understanding of contracts and what could happen. So partial performance, what does this term mean? It means that one of the parties did not do everything the contract required of them to do. So therefore, they're in breach of contract. Substantial performance. It means that the party did everything the contract required them to do. They just did not do it exactly as the contract required them to do it. So they have not substantially performed. Okay. The best kind of explanation I could try to give you for that is I'll give you a visual. It's not technically what they're talking about here, but I could give you a visual on it. Let's just say that I'm a contractor that you hired to remodel your kitchen. You wanted me to replace the kitchen countertops and cabinets, right? And you wanted these nice 42-inch cherry cabinets installed with the little glass and etching in them. And you wanted me to put in some granite countertops and, all that nice stuff. And instead, I put in some plain cabinets on the wall and some linoleum countertops. Hey, I remodeled your kitchen. I just didn't do it exactly the way you wanted me to do it. All right. So I have not substantially performed there.
Okay.
I did everything you wanted me to do. I remodeled it, just didn't do it exactly the way I was supposed to.
Got it.
Now, impossibility of performance. It's when the contract cannot be carried out because of various reasons. It's impossible to do. For example, I couldn't get the permit to use the property for the purpose that I wanted to use the property for. So then I don't need the property. Why should I lease or purchase a property if I can't get a permit to build a house on it? Or if I can't get a permit to use the building for my business because they don't allow that kind of business to be zoned there, So that's impossibility of performance. And usually, developers do this when they purchase land that they're going to put into a subdivision or what have you to build houses on, or condo complex or whatever. They usually put a condition in the contract that the contract is subject to. That's a very powerful clause. Subject to means this is my way to get out of the contract if this is unable for this one thing to happen. Subject to me getting permits from the city to build what I want to. Subject to whatever the other requirement is, okay? All right, by mutual agreement, both parties can just back out of the contract, okay? Nobody's in breach in contract if that's the case, but they could just both back out. Or by operation of law, as in voiding a contract with a minor, expiration of a statute of limitations, a time limit, a legally required time limit. Contracts being altered without all the parties agreeing to it or not all the parties signing them. Anytime you make a change to a contract, everybody has to sign or initial next to each and every change. The second that you touch a contract with a pen and you alter it, you just voided that contract, my friend. unless you had all the parties to that contract initial. I have them initial and date next to every single change. Because then later on, they can't say, oh, I never agreed to that. Sure you did. Your initials and your dated right here. Right? Or as a result of fraud, for instance, maybe. Maybe you got the husband and the wife to sign the contract, but the wife wasn't really the wife. She was the girlfriend posing as the wife. Remember those stories? All right. So what happens now? In the event one of the parties breaches contract, what is breach of contract? When somebody violates the terms of the contract without having a good legal excuse to do so. Then they can be held financially and legally liable to the other party. All right. So what can you do if the other party violates the contract? Well, we're going to go over what happens if the seller defaults, and then we're going to go over some scenarios if the buyer defaults. But before we do, here's another legal term you have to add to your definition list because it is on exams. Exam. I don't think it's on a school exam. Maybe I'll add a question about it, but I know it's on state exam all the time for some reason. You have to know this term, injunction. What is an injunction? It's when a judge orders somebody to do something or refrain from doing something in a contract. Okay? That's all it is. It's when a judge orders somebody to take action or refrain from taking action. Okay? That's not written here. I think it's much later somewhere written in the book, an injunction. Actually, it would be a good place if I had a page reference to it right there. Somebody can look up what page the word injunction is on for me. That would be a great help so I could keep going on with this. Now we're going to talk a little bit about if a seller defaults, what can the buyer do? Well, the buyer can rescind. That means that they can cancel the contract as if it were never made, and they get all their deposit money back. Or the buyer could sue the seller for something that we call specific performance. Performance means somebody was required to do something, right?
Right.
If you're suing them for specific performance, you're trying to force them to do something that they agreed to do. You're trying to sue them to specifically perform as they agreed to. Okay? You need to know the term specific performance. We'll highlight it in a few minutes. I'm just giving you guys the explanations right now. Okay? So the lawsuit is called a suit for specific performance. And here's an example of that. At the closing table, the seller just decides, I don't want to sell no more. I'm not signing. You know what? If I hold on to it, I may be able to get more money. I changed my mind. The buyer's flipping out. They're like, wait a minute. I got all my stuff in a moving truck. I got nowhere to go. The buyer can sue the seller, forcing them to turn over the ownership of the property to them as they agreed to in the contract itself. Okay, that's what specific performance is. And then the judge can order an injunction forcing the seller to sign the deed and hand it over to the buyer. Okay. Now, general rule of thumb, you can force a seller to sell, but you cannot force a buyer to buy. Generally speaking, not all judges rule uniformly, so you could have a judge that makes some kind of wacky decision sometimes. But generally speaking, you can't force a buyer to buy. If we were to flip that scenario, that the buyer decides they get cold feet and they're back out of the contract, you know, you can't, normally, a judge will not force a buyer to take on a 30-year mortgage to purchase a property that they don't want anymore. There's other alternatives that a seller can do. They could sue them to get money, etc. There's other things that they could do. But generally speaking, a judge is not going to force a buyer to take on a 30-year mortgage to buy a property they don't want. After further evaluation, they realize this property is the money pit. What the hell am I doing? And they change their mind, right? So unless the buyer's a moron. Just keep note of that for a moment. So generally speaking, a court, generally speaking, you cannot force a buyer to buy unless they're a moron. I'm going to stand by that statement, and I will give you an explanation of it when we get to what the buyer's alternatives are, or what the seller's alternatives are. Okay, and there's one more thing. The buyer can sue the seller for compensatory damages. That means for money. Okay, the seller refuses to sell to them at the closing table. You know what? That buyer, they got nowhere to go now. They got their stuff in a moving truck. You know, they've got all kinds of additional stress and, you know, pain and suffering and damages. And, you know, they got money into this transaction as well. They got attorney review. They paid for inspections and insurance and all kinds of other monies, appraisals and such, title searches and surveys. You know, they got a lot of money in this. So they could sue that seller for a lot of money. That'd be an unwise decision for a seller just to change their mind at the closing table. Usually it would be the other way around. Did anybody find out what page number that injunction was on by chance or no?
I was
No,
looking,
I
I
tried
couldn't
to
find
look.
it. It's not even, I looked in the index and the back and the definitions, it's not there.
Yeah, it's somewhere. It's somewhere
Same.
here in this book. Not sure where it is, but it's not, they don't have it listed there in the index, huh?
No,
I know I've seen it somewhere. Not sure what chapter or paragraph. So I'll look that up and try to update the cross-reference for an injunction. My sticky pads. Let's find out real quick what slide number this is so I can make that note. Breach of contract. Slide 22. Slide. I'll look it up. I'll find it later and I'll update it in the slideshow. All right. So what can the seller do if the buyer defaults? Well, first, before we get into that, let's read this term. Here's another term. By the way, did I tell you guys when we started this chapter that there's a lot of questions on state exam from it?
yes.
Contracts. Okay, so liquidated damages, another term to know for exams. It's an agreement. Stop. That's it. Liquidated damages is an agreement. Now, what's the agreement about? It's an agreement that is made in advance. It's usually written into the contract itself.
Mhm.
If it's added to the contract. It's not by default in all contracts. Someone would have to add it. That states that in the event that one of the parties, usually the buyer, if they breach the contract, it's an agreement about how much money would serve as compensation in the event that the buyer breached the contract. Now, it doesn't necessarily say where that money's coming from. So if on exam you get an answer option, they put in there, you know, the deposit money, the escrow deposit as an answer for what liquidated damages is, that's wrong. Because it doesn't say where necessarily that money's coming from. So we got a little side note here that I wrote. There could be additional wording stipulated as to where that money would come from. However, if they do state that in a contract, that the damages would be paid from the earnest money deposits that the buyer put down when they were purchasing the property, then the other party could not collect any additional money other than whatever the deposit money amount is. See, otherwise the liquidated damages agreement could be for a figure that is far more than the deposit money that they put down. But if they state that the earnest money is going to serve as liquidated damages, then they can't chase after the buyer for any more than that amount. Okay. So what are liquidated damages? It's an agreement of how much money serves as compensation if one of the parties breaches the contract. Good. All right. Let's see. Now, if the buyer defaults, what can the seller do? Well, the seller can declare the contract forfeited if the contract stated they can, and if it was agreed upon that they would be awarded compensation from the buyer as liquidated damages. But those are all big ifs because liquidated damages are not standard in all contracts. Okay, here, let's add that in there. That's a big if, right? Okay. All right, now the seller can rescind the contract as if it were never made. However, they would be required to return all the deposit money back to the buyer. The seller can sue the buyer for specific performance, but remember with this one, I told you that only applies if the buyer's a moron. Well, let's continue reading what's written here. However, this would require them to sign over the deed to the buyer and then chase after them for payment. Oh, so when does the transfer of ownership of real estate take place? Upon delivery and acceptance of the deed itself, right? So the seller signs over the deed and they give it to the buyer. The buyer accepts the deed. Now the seller goes, "Oh, you're now the owner, but you got to pay me. Would you think I was going to just give it to you?" Okay. You'd have to be a moron. If you don't want the property, don't take the deed. Buyer's signature is not required on the deed for it to be valid. Only the seller's is. The buyer's information stated that they're going to be taking the ownership has to be named in the deed, but only the seller needs to sign it for it to be valid. And the transfer of ownership takes place upon delivery and acceptance of the deed itself. Okay, so if you don't want the property, why would you take the deed in the first place? But if you do take the ownership, of course you got to pay them for it, right? Then the judge can force you to sign and pay the buyer, pay the seller for the property that you just took the ownership for. And then the last option is the seller can sue the buyer for compensatory damages as well, for payment. That's what that means, compensation for payment. That's what compensatory damages are. Okay. All right, so let's do some highlighting. Under default or breach of contract, let's highlight the first line. Breach of contract is a violation of any of the terms and conditions of a contract without a good legal excuse. And then we'll either underline or put in a box or what have you, just so that you know this is the title for the next section. If the seller defaults, the buyer has 3 alternatives. And then do that same thing to the title for the next section that says if the buyer defaults, the seller may pursue one of the 4 courses. Okay, either put that in a box or underline it, little star next to it, just so that you know that's just a title. It's a new section, something different. So then we're going to highlight number 2, a court suit known as an action for specific performance to force the seller to perform the contract, i.e. convey the property. And then in the next section, under if the buyer defaults, the number 1, we're going to highlight the term liquidated damages and then write page 189 next to it. And then we'll go to page 189 so that we can highlight the definition there, which is still in this chapter. And at the bottom of page 189, we're going to highlight liquidated damages is an amount of money agreed to in advance to the by the buyer and the seller that serves as compensation if one of the parties does not live up to the contract.
And you said this is not standard?
It's
This is
not.
an if?
It would have to be added into the contract. It's not a standard part of every contract. It would actually have to be written into the contract itself.
So who would usually write this up in the contract? The buyer?
The buyer's agent
Hmm.
or the seller's agent rather, because usually it's if in the event that the buyer defaults, the buyer backs out. So it's usually the seller's agent would demand that the buyer's agent who's preparing the contract add that wording in there.
Okay, thank you.
You're welcome. I just remembered what chapter injunction was in, so I'm just trying to look it up really quick. I know it's in the next chapter, chapter 12. Knows it's in here somewhere. All right. Give me 2 more seconds here. Just trying to scan this chapter really quick. I know it's in chapter 12. Injunction. Oh, I'm sorry. It is not chapter 12. It was chapter 4, the discrimination chapter. Where a judge can order somebody to pay a fine or make restitution to somebody or rent to somebody who they previously were not going to rent to. So the injunction is in chapter 4. There we go, page 67. All right, so I probably had you guys highlight that, but I don't know because we're mixing and matching these classes here. So page 67, if you turn to that so that you could highlight injunction, this would order the offender to take action. Okay, it's 3 paragraphs, it's under enforcement in the second paragraph on the first line. Injunction, this would order the offender to take an action. What's that here? Okay. So back to page 171, the bottom of the page, Statute of Limitations. What is a statute of limitations? Anybody ever hear that term before? It's a time limit in which one has a right to assert their legal rights. The way they word it here is New Jersey allows a specific time limit of 6 years during which a party to a contract may bring legal suit to enforce their rights. Any party who does not take steps to enforce their rights within this statute of limitations may lose their rights. So it's a time limit which one has a right to assert their legal rights. Okay, that's what a statute of limitations is on page 171 there. So we're going to highlight statute of limitations. This 6-year period applies to contracts, foreclosures, mortgages, and cases of fraud. Lawsuits to recover real property have a 10-year statute of limitations on them. Then I got that little note there at the bottom of this slide. How long do brokers need to keep all records for?
6 years.
6 years. Huh. What's the statute of limitations for contracts?
6 years.
Years.
Huh. Is that a coinkydink, you think?
No.
There you go. Now, the rarer instance where somebody is trying to recover their property, there's a 10-year statute of limitations. Okay. So there you go. I think one of these may be on exam sooner. All right. Contracts used in the real estate business. The rest of this chapter is pretty much going to be, we're going to go over some new stuff, but it's pretty much going to be a recap of a lot of the forms and things that we've already gone over up until the point that you get to a contract. And then when you get to a contract, we're actually going to fill in a contract too. Okay. I'll show you how to fill a contract in as well. All right. So a lot of this is just a recap. So we're going to go through it a little bit quicker. Well, what kind of properties can licensees prepare contracts for? Residential 1 to 4 families only and single residential lots, right? And you got this little note here. We fill in the blanks. We don't actually write the contracts from scratch. These contracts are already prepared by legal counsel, approved by the real estate commission for our use. Okay. It would be impossible to create a universal contract for all kinds of properties that are out there, residential, commercial, etc., industrial. So, but for 1 to 4 family, it's pretty standard. So there's this one universal contract for those types of properties. Okay. Who prepares the contracts for commercial and industrial properties for sale or lease, or residential properties over 4 family?
We do.
An attorney does. We only prepare contracts for 1 to 4 family and single residential lots. Commercial, industrial properties for sale or lease contracts have to be prepared by attorneys. So how do we write? I mean, we're allowed to sell commercial and industrial. We're allowed to lease commercial and industrial. How do we get the ball rolling? We prepare what's known as a non-binding term sheet or an intent to purchase or lease the property. Okay. Now, and then basically we go back and forth in that. It says at the top of the page, you know, this is a non-binding intent to purchase or lease or a term sheet that is not binding, meaning it's not legally binding and is subject to a formal contract being drawn up by legal counsel. That means one of the attorneys. So we go back and forth, get the parties to agree on all the terms that they want added into the contract, all the key terms of the contract, right? And then the attorney draws up the custom contract with those agreed upon terms. Then the people will eventually have to sign that agreed upon contract. All right, so New Jersey's requirements. So under preparation of documents, highlight the first sentence.
Okay.
Even though the whole paragraph is pretty good, just highlight the first sentence. The second sentence says, to avoid the practice of law, we don't prepare contracts for commercial industrial property or option agreements, right?
No option.
No options. We don't prepare options. All right. So New Jersey requirements state that they must indicate the business relationship with respect to the parties named in the document. So highlight all offers, contracts, or leases prepared by licensees must indicate the business relationship the firm has with respect to the parties named in the document. And then they quote the Real Estate Commission's rule that requires that. How do we first disclose our relationship with the parties?
CIS.
CIS form, correct. But in the contract itself, we also disclose it because look, this thing just said that, right? So let me pull up a contract, even though there's a contract in the upcoming pages here. I'm going to pull up a sales contract as well. Put that up on screen so that we keep referencing it. And as you guys can see, in the sales contract, there is a section where we disclose our relationship to the parties. I'm looking for it right now. Show you what that looks like on the contract. There we go. It's the checkbox where you're checking off your agency's representing the seller, the buyer, disclosed dual agent or transaction broker. That's how it looks. This is the declaration of business relationships. Okay. Now, attached as a proposed contract of sale is the cover page. What must be the cover page of any contract prepared by licensees?
Option.
Opinion. That would be the
Oh, whoops.
opinion basics notice. Yes. So, highlight attached as a proposed contract of sale as the cover page must be the notice. And right above that, opinion 26 notice, page 174.
Wait, say that again, Victor. I'm sorry. What you said?
Sure. You're going to highlight attached as proposed contract of sale as the cover page must be the notice. And right above the word notice, opinion 26 notice,
Opinion.
page 174. And this is what you see on page 174. It says notice, right? That's why the book simply refers to it as the notice and not the opinion 26 notice. So on page 174, I want you to write above where it says notice there, I want you to write opinion 26. So that you don't forget.
This is the disclosure of agency relations.
No, the disclosure of agency relationships is just the checkbox where you say your agency, this is the disclosure of agency, the declaration of business relationships. You're checking off.
That's the boxes.
Yeah, these are the boxes here.
Okay.
Okay. Now, the first time that you disclose this to people is on the CIS form.
Right.
But in every contract for sale or lease
This
that
needs-
licensees prepare,
yeah.
it has these check boxes on them too. See,
Okay.
this is why I'm showing you, because I want you to see what it looks like too in the contract. This is what they mean by that the contracts have to disclose the relationship of the parties. How do we do that? Well, by a checkbox. Okay, giving you a visualization here. It's a checkbox, that's it. Okay. And then the opinion 26 notice that's sitting here as the cover of the cover page of the contract. Look, it's even before you see the first page of the contract. It's the cover page. What is the purpose of this document? Anybody? Anybody?
The right to an attorney?
It's your right to hire an attorney. Correct. So, we went over this, I think, in chapter 3 too, didn't we? Well, look, in this opinion 26 notice, it says the law requires real estate brokers to give you this information before you sign the contract. It requires us to tell you that you must read it all before you sign the contract. Okay. And then look, even on this form, what is this? What is this right here? The number 1. That's a disclosure of agency relationships again, isn't it?
Yeah.
Every disclosure, every contract, with the exception of the lead paint addendum, every disclosure, every contract that we have has a checkbox like this where we're disclosing, as of now, who are we representing? As of now, how are we representing them? Right? And this is just that big fear-mongering document that tells people that they should hire an attorney. Do you need to have an attorney in real estate transactions? If you're buying a house, do you need to have an attorney?
You don't have
No,
to,
but you're suggested.
but they.
But they
you
what?
don't-
No, you don't need an attorney.
You don't need an attorney, but they give you
But
the
it's the right.
option to have it.
It's an option. Okay.
Mhm.
Now, so you don't need an attorney,
No.
but you better not tell anybody that.
Right.
As a matter of fact, the law requires that we tell people that they have a right. We have to inform them of their rights to hire an attorney.
Right.
Okay. So that's what this document does. It's a big fear-mongering document because a lot of real estate agents in the southern part of New Jersey used to do business in a little more aggressive manner where they do real estate in a way that agents in other states most other states do not have an attorney review period.
No, they don't.
Most states do not.
No.
So, I remember the first time I found that out. I'm thinking I know about New Jersey real estate when I got started in real estate, right? I've done a couple contracts. I know what I'm doing here. And then I get a referral of business from an agent from a different state. All right. I forget if it was a buyer or seller, but we got an offer, or we made the offer, I forget. And it was an attorney review. And so the agent was calling me to do a follow-up to see where the transaction was, or if we had a transaction going. And I was like, oh yeah, we're still in attorney review. And the agent flipped out at me on the phone. They're like, what do you mean they're in attorney review? Well, what's going on? What happened? Why is there an attorney involved? And I can't comprehend why this guy's flipping out with, on the phone to me, you know? And I'm like, what do you mean? Why are we in attorney? Because we have to be. It's part of the real estate transaction. You know, the party signed the contract, it goes to the attorneys review it, make changes, you know. And he's like, well, why is an attorney involved? I'm like, well, because it's the standard way we do business here. You know, we sign the contracts, we send it off to attorneys. The attorneys make any changes to the contract. And when they conclude attorney review, they're now in a legally binding contract. See, that's when that agent explained to me, they're like, well, in our state and in most other states, attorneys are not used in real estate transactions unless there's a problem.
Right.
Usually the real estate agents are going back and forth with those term sheets like we do with commercial real estate here in New Jersey. You know how we negotiate all the terms of the contract before we actually draw up the contract? In New Jersey, we do things kind of, for lack of a better term, ass backwards. What do? When we write up the offer, our offer is the actual contract. And if the contract is signed by both parties, we can't make any changes to it. Otherwise, we're practicing law without a license. See, agents in other states and the southern part of New Jersey are more accustomed to, they go back and forth with that non-binding term sheet until all the parties are in agreement on all the terms and the words to be added to the contract. And then they draw up the contract one time with all the agreed upon things. And then you don't need an attorney to make modifications to it later. You only need an attorney if there's a problem. So years ago in the southern part of New Jersey, one of these agents, you know, landed on their, started marketing that. They said, hey, that's a great way to market myself, right? Let people know that if you hire me as a real estate agent, I take a more active role in the transaction, and I could save you the cost incurred of hiring a lawyer. That landed in a lawyer's mailbox. What do you think their reaction was? We can't let this go. But they're like, wait a minute, that agent's not wrong though, rats. But how can I stop him from doing this? He's taking money out of our big fat wallets already. Well, the agent wasn't saying anything wrong. People don't need a real estate, an attorney in a real estate transaction. So the attorney came up with a bright idea. Boom. Who makes the laws? Who makes laws, guys?
Congress.
Politicians.
Politician.
Politicians do, right? We're looking at the state level here, okay?
Oh,
Yeah, but we have our similar thing to the House of Representatives and the Senate. It works the same way here. And then when the House of Representatives proposes the law, once they pass it, it goes to the Senate. Senate has to agree to it. Once the Senate agrees to it, it goes to the president to sign, right? Those are for federal laws, right? State laws kind of work the same way. We kind of got our House of Representatives here in the State House, right? In New Jersey. They agree to it. It goes down to the other house. You know, they have to agree to it. And once it's all agreed upon, then it goes to the governor, and then the governor can sign off on it or kick it back to them to make changes. Okay. It works the same way. It's just like a mini version of the national government. It works the same exact way though. All right. So the governor doesn't make laws, just like the president doesn't make laws. Yeah. Governor can make orders in case of emergencies or stuff, but then they're not laws, and they could always be kicked out or rejected by judges or what have you, because it's not the law. Judges enforce law. That's like what we got President Biden now. What he's doing is he's doing the things that a lot of presidents do. They write executive orders, right? An executive order, though, it can always be overturned. Look, that's what Biden's doing. His pen, he's getting cramps in his hand. He's trying to, you know, overturn everything that Trump did, right? With executive order. All right.
Yeah.
And see that's how easy it can be. But if they went through the legal process, the law is a lot harder to pass laws because it's got to go through the different chambers, right? Well, either way, in New Jersey, with this scenario here, this attorney said, wait a minute, we got to put an end to this. Now, do politicians actually write the law, or do they just legislate what they want the law to be? And then they give it to attorneys who will actually write it up and into the legalese meanings. See, even our legislators that we have, some of them are attorneys or former attorneys, but some are doctors, some of them are just regular schmoes, right? And what they do is they come up with the idea for the law and the ideas that should be put in the framework, and then it's actually drawn up by an attorney. So this attorney just drew up the law on his own, introduced it to to the political politicians, and said, "Hey, listen, here's the deal. You got real estate agents running out there telling people, not informing them that they have a right to have an attorney when dealing with real estate contracts, the single most expensive transaction that they're going to make it in their lives, and they're putting their clients at risk. That they're also walking a borderline of practicing law without a license. So here's a law that I propose that requires real estate agents not to tell people that they don't need an attorney, but to inform them that they have a right to be represented." And politicians being more than happy to be like, "Oh, this is to protect the public? Okay, I'll pass the law." And so they did it. And thus the Opinion 26 notice was born. And now it's just another piece of paper that we got to use here. And we cannot tell people they don't need an attorney. We have to advise them that they have a right to hire one. You don't believe me? Let's read this document a little bit further. What does it say? "You will not get any legal advice unless you have your own lawyer. Neither I," that's you, the real estate agent, "or anyone from the title company can give legal advice to either the buyer or seller. If you don't hire a lawyer, no one will represent you in legal matters now or at closing." Ooh, scary. "Neither I nor the title company will represent you in those matters. And the contract is the most important part of the transaction. It determines your rights, your risks, and your obligations, and signing it's a very big step. You see, a lawyer would review the contract and help your feeble minds better understand it." Now, I know it doesn't say that, but kind of does, doesn't it? "And to negotiate its terms. So the contract becomes final and binding unless your lawyer cancels it within the following 3 business days. And if you do not have a lawyer, you cannot change or cancel this contract." And what's that next word? Unless. So that means that you can change or cancel the contract if the other party agrees to it. Look, the other lawyer is not going to be able to change the contract without the other party's agreement. They could cancel it without the other party's agreement. They can't change it. Right. Now, as you can see, this is just a big fear-mongering document because it goes on to talk about other lawyerly duties, things that they do, but they take that upon themselves. Real estate agents can do this. The buyer can do this on their own. Another important service of a lawyer is to order survey. The buyer can order survey. The real estate agent can order survey and title search, right? So that's usually just another way for attorneys to make money too. Well, title. A lot of them own their own title companies, for crying out loud. Anyway, getting off track there a little bit. But that's basically it. What is the purpose of the Opinion 26 notice? The document that needs to be the cover page of any contract that licensees prepare. Really? Why are you guys so quiet?
To advise to get a lawyer. I'm sorry, an attorney.
They advise you it's your right to hire a lawyer. Correct. All right. So let's now go down to the next paragraph. New Jersey also requires the following language appear exactly in this form at the top of the first page of the sales contract. We'll highlight that. Then we're going to highlight this is a legally binding contract. And then we're going to put a box with our pen around that sentence just before this is a legally binding contract that says New Jersey also requires the following language to appear exactly in this form at the top of the first page of the sales contract. And we put a box around that, those two paragraphs there. And you're going to write to the left of where it says this is a legally binding contract, page 175. And you're going to turn to page 175, which basically is the first page of this sales contract. That's the sales contract. And it says, what does it say under the New Jersey Realtors logo here? You guys already have that highlighted in your book or no?
No.
No.
Highlight
No.
it. Okay, go there and highlight it right now.
What are we highlighting?
This is a legally binding
This is
contract.
a legally
On page
binding contract.
175, the first page of the contract. See this paragraph here?
Mhm.
Yeah.
What are the first words here? This is a legally binding contract. Legally binding contract.
Okay.
Everybody got it highlighted?
Yep.
All right, now you can't say I didn't tell you to highlight it. Because that will be an exam question. Hint, hint, wink, wink, nod, nod. What are the words on that could be found at the top of the first page of any sales contract prepared by sales or lease contract, any contract prepared by licensees?
This is a legal
This is a
binding.
legally binding.
And what
contract.
needs to be the cover page of any contract, sales or lease contract prepared by licensees?
Notice 26.
Opinion 26.
The Opinion 26 notice. And what is the purpose of the Opinion 26 notice?
The right to hire a lawyer.
That's it. There we go. Thank you. Now, how soon do you have to have that lawyer review that contract? Otherwise, that contract becomes legally binding as it is.
3 days.
Was it 10 days?
5 days?
3 days.
3 days. Yes. Sean, you could talk. You don't have to text. And Anna and everybody who's been, Monique, everybody who's been texting me here. You can talk. All right. Yeah, the attorney review is 3 days. So the next part we're going to go over is we're actually going to go over the attorney review process and how that actually works. So if we go to the book, let me see, do I have this actually on the slideshow? Let me go to the slideshow. So I have these things on the slideshow, the notice, the cover, it needs to be the cover page of any contract prepared by licensees informing consumers of their rights to hire a lawyer. And then this talks about the federal lead paint. This is on the next page. I just exposed it onto the slide here. But in the contract itself, it also states that we had to have, we gave the person the lead paint addendum and the 10-day right to hire an attorney, and we gave them the pamphlet as well. It says that in these on this line number on the actual sales contract, for if the property was built prior to 1978. Getting back to the attorney review. Let's see. So, yeah, you can see this one slide here. What does it say in the top of the first page of the contract? This is a legally binding contract, right? We just highlighted that. Now, over here for attorney review, this is the way that it works. Highlight the title attorney review and put a box around all 3 steps, which continues on to the next page. All 3 of those steps. So these are the steps you see on the slideshow in front of you. This is the way attorney review works. So the contract, the contract, whether it's for sale or lease, right now we're in the purchase contracts in this chapter, so we'll just talk about the purchase contracts. But the Opinion 26 notice needs to be the cover page of any contract that we prepare. So that includes lease contracts too. So this is the way it works. When both parties sign the contract, we got to give them what right away? A duplicate original, right? Of that fully executed contract. And then the counting of time works from the time that we give them their duplicate original of the contracts. Counting of time, we have to start attorney review within 3 business days. We don't count weekends or legal holidays. So we have 3 business days. Now, let's just start that attorney review. Now, the attorneys can extend that period, or they could put a pause to the attorney review period. Or we could have both the clients themselves pause it or extend that period if they agree to it. But otherwise, the attorney review is 3 days. What does that mean? It doesn't mean that attorney review is 3 days. It means that from the time that both parties sign the contract and get their duplicate original of it, that we have 3 days to start the attorney review process. Otherwise, the contract becomes legally binding as it is, and then neither party can make changes to the contract. Okay, not unless they both agree to all the changes. So, we send the contract out to both sides' attorneys to start the attorney review. One of the attorneys are going to start the review process by sending out a letter to the other. We call this the notice of disapproval. Okay, the notice of disapproval works like this. The letter says, we're in receipt of your contract for the purchase of 123 Main Street, or whatever the address is. However, we disapprove of the contract in its current format. However, if you agree, this attached laundry list of changes that we had proposed here, and then they'll have all kinds of modifications to the wording, striking out line numbers or sections of the contract and replacing them with their own verbiage, right? And then they'll send it off to the other side. And if the other side agrees to all those changes that they've made in the wording, then they'll sign off on the contract and attorney review is concluded. It's been signed by both attorneys now, both of the parties' representatives, legal representatives. If not, if they send it to the other side's attorney and they don't agree to it and they want to make some more of their own modifications to the wording, then they can do so. And then they'll send out another letter of disapproval to the other side. How long do they have to do that? 3 days.
3 days.
See, attorney review is not 3 days in total. It's just that each party has 3 days to communicate or respond to the last communication of the other. So when we say that we're extending the 3 day attorney review period, if both parties agree to extend it to 5, 7, 10 days, whatever it is, or they put a halt to it until something happens, then they can do so if they like. But if they don't, the way it works is each party has 3 days to respond to the last party's communication. If they don't, then the contract is legally binding and the other side doesn't have to agree to any other changes. It becomes legally binding as it is. So that's why it's very important for us to get all the attorneys' information and get the ball rolling as soon as possible after everybody signs the contract and we get their duplicate originals to them, right? Now, don't just fax or email the don't just scan and fax the attorney review to the, the contract to the attorneys. Also, call them up to ensure that their office received the contract. Call them up to let them know that you want them to, any changes that are made during the attorney review process, that you want them to include the real estate agents in those communications. Now, I also do that. I also include, when I send the contract to the attorneys, I also include a cover sheet that has all the players on it. Like on the left-hand side of this sheet, it'll be the seller's info. The right side, it's the buyer's info. And in the center, there'll be an area for the mortgage company and the mortgage rep that's handling it with all their emails and everybody's, the attorney, the seller's information, the seller's attorney, and the seller's agent's information's on the left side. The buyer's attorney, the buyer's info, and the buyer's agent's info on the right side. the buyer's lender is in the center, and all their contact information there. And then I'll put a cover page even above that, where I write a note asking the attorneys to please, here's all the everybody's information, so you don't got to go hunting around for it. It's all here prepared for you in a contact sheet. Just please include the real estate agents in all communications between attorneys, all correspondence between attorneys, so that we're aware of what the hell is going on, right? Now, one thing that's interesting, if we were actually to read this, and, you know, I was having an interesting conversation with another instructor the other day about this. I got an instructor that's teaching a broker's class, and he's talking about legal cases and situations. See, sometimes in the past, I've had problems with attorneys not communicating with us as far as what's going on during the attorney review process. But let's see what it says here. So study of the attorney. The buyer and seller may choose to have an attorney study this contract. If an attorney is consulted, the attorney must complete their review within 3 days. This contract will be legally binding at the end of the 3-day period unless the attorney for the buyer or the seller reviews and disapproves of the contract. Then the other side has 3 days to reply to them, right? He talks about how the counting of time works. And then it says under the notice of disapproval, if an attorney for the buyer or seller reviews and disapproves the contract, the attorney must notify the broker and the other party named in this contract within the 3-day period. Otherwise, this contract will be legally binding as written. The attorney must send a notice of disapproval to the broker by certified mail or by telegram, or by delivering it in person. The telegram or certified letter will be effective upon sending. The personal delivery will be effective upon the delivery of the broker to the broker's office. The attorney may also, but need not, inform the broker of any suggested revisions in the contract that would make it satisfactory. See, basically, that's why I write that cover letter that says, hey, attorneys, when you're doing the attorney review, you need to keep us informed. If the agents aren't informed of the changes that you're making to the wording in the contract, if it's something that we need to do that's different, how are we going to know that unless you inform us? You know, I've had some attorneys give me problems with this for whatever reason. They got a bug up their butt. So I would ask, if I'm working with the seller or the buyer, I would ask them to talk to their attorney and instruct them, because their attorney works for them, to instruct them to communicate to CC, to carbon copy, the real estate agents on all correspondence between the attorneys during the review period. All right. Because if you don't, there are a few attorneys, most attorneys will do it without a problem, but some are a pain in the ass that they just won't do it for some reason. And as you see here, they don't have to. Okay. However, what they do have to do is, if the contract is initially disapproved and they don't tell us that, how do they have to notify us?
Certified mail or telegram.
Yeah, so they're either going to approve of the contract within 3 days, and we know just to keep going with the contract because it's been approved if we didn't hear from them, because they're legally, attorneys are obligated to let the real estate brokers, the agents, know in that transaction if the contract's been disapproved. And how do they have to do it? By certified mail, by telegram, or they could deliver it to our office in person. There's nothing there that says they could email it or fax it. And I was having an interesting conversation with it. I got another instructor that's teaching a broker's class now, and he was talking about a legal case that he's got as an example he likes to talk about. It's an interesting conversation when we talk about the law. and how it works. Sometimes it's like we're attorneys the way we're talking about law, you know. Just remember, you're not an attorney. But the legalities of it are interesting because the wording here, attorneys may often violate this.
Yeah.
And if that's the case, if a broker really wants to make an issue out of it, they could sue the agent, they could sue the attorney, because the attorney violated the law. The attorney had an obligation to notify us, and not just by email or fax or by phone. They had to do it by certified mail or by delivering the contract in person to us. And I can honestly say I had that sent certified mail to me twice in my entire career so far.
So how do they get back to you then?
And they're constantly starting attorney and doing attorney review. So that means that there had to have been a letter of disapproval sent out, right? I don't think I ever had a transaction. Oh, actually, I had one transaction ever where the contract was just accepted. The attorney didn't do any letter of disapproval and make any changes. Okay, that happened one time ever for me. So every single transaction since 2004, it's now 2021. I've never had I've had 2 instances of attorneys actually sending it out by certified mail. All right.
And how do
First of all, most brokers don't know about this. You know, they don't actually read the review process. They just send it off to the attorneys and they let their do them process. But plus, why are you going to start static for? Why are you going to sue the attorney for? Because they didn't let you know? Well, you know what? I could see doing it if they want to be a ball buster to me. Like if they're not including me on all the correspondence between the attorneys. I'd be like, you want to make my life difficult? I can make yours difficult too. You know, you violated the law when you never sent me the notice of disapproval by certified mail or in person. Because the Supreme Court has ruled on a case on this. So I don't know what that whole situation is, but I want to find out because now my interest is piqued, just my intellectual, for intellectual reasons, but not necessarily me wanting to sue an attorney. Okay. But I want to know more about that case. You know what? So I'm going to try to find out for you guys. And I'm going to post something about it on our Facebook page. I'll maybe do a little write-up of it with references and stuff. Put it on our Facebook page for you guys. Okay.
Okay.
Or on our future website, I'll have a little section with blogs and stories. I'm going to add it there too. All right. So can attorney be done in one day? Can attorney review be done in one day?
No.
No, that's 3 business days.
Nope. I could send out the contracts to the attorneys and they could go back and forth 10 times in one day and conclude attorney review. They could do it they could be done with it in an hour. I had an attorney review done in an hour one time where 2 attorneys, I guess they had nothing else to do. They were right on top of it. As soon as it came, boom, sending their review letters back and forth to each other a couple times, and boom, they were done in an hour. Now that
So it can be done in one day, right?
What's that?
So it can be done in one day.
Yes, it absolutely can.
Okay.
They
It's
just have up until 3 days.
They have up to 3 days to respond to the contract and either give that's the counting of time and make their disapproval or acceptance. All right.
Okay.
So attorney review is not necessarily 3 days. I've had attorney review done in an hour, and I've had attorney review last 3 months.
What?
Yes.
Oh, no.
Attorneys just keep going back and forth. And then they extended the period of time. And then they halted it until something happened. You know, I think this was a short sale. They halted it until they got an approval from the seller's lender before they continued the attorney review. They did it. It was kind of retarded the way they did it, you know, but that's the way they did it. You know, who am I can't, once we send it off to the attorneys, that's between attorneys. They're practicing law. We can't interject in that because we're not practicing law. Our job is just to make sure the attorneys are still communicating back and forth with each other. But if they've halted the review until a certain happening and the happening didn't occur yet, all we could do is make sure that happening occurs, whatever it is, right? Get that lender's approval if that's the happening that it was, right? All right. So once both sides' attorneys have come to agreement on all the final wording that they want entered into that contract, it's said that they've come to a meeting of the minds. Both parties have come to a meeting of the minds, just like when the buyer and seller originally signed it, right? And then they signed that final contract, concluding attorney review. And that's when we got all the final changes done to the contract. And now they're in a legally binding contract once attorney review is concluded. Now you as a real estate agent should take notes in your real estate binder. You'll have a folder for your transaction that you're going to put the contract in, all the disclosures, any documents pertaining to this real estate transaction you're going to be putting in this binder. I usually like to have the cover of the binder, or I'll staple a piece of paper to the binder, and then I could staple more if I need to, where I make my notes. And I will make a note there, or I'll write it on the binder itself for dates that I need to be aware of. For instance, if the buyer needs to put down a second deposit, that they need to come up with a certain amount of money by a certain date, so many days after attorney review, or the date that they need to have the mortgage commitment letter from their lender by. I'm going to write those dates down and put down what my deadline is, and to make sure that I follow up on them and meet those deadlines. Okay, it's just my little notes for myself, and I make a habit of doing that. And I tell you what, if you make a habit of making notes in the cover page there, the inside cover of the transaction folder, that could save your butt someday in the event of a lawsuit. You know, written notes, if you make a habit of doing that and you say, hey, listen, I got this transaction folder where I got my notes written on the cover there. You know, somebody could say, oh, you wrote that in afterwards. Well, if I could show you previous transactions that I have where this is a habit of mine, I do this all the time, this is not something new that I've just done, then I could win a case. It could be that could be construed as evidence that I put dates, I made notes in the binder, in the inside cover, then I could cover my butt that way. All right. Always have stuff in writing, because you never know. All right. Contracts. So using the contract forms, we fill in the blanks. We don't write these contracts from scratch. We have, first of all, we have listing agreements. We have buyer brokerage agreements that we go over on page 40. So on page 173 here, next to buyer brokerage agreements, just write page 40, because that's where we went over them back in chapter 3. And next to where it says transaction and dual agency agreements, write page 47. There's actually 4 types as well. Remember that there's a disclosed dual agency agreement for
Sorry, can you repeat the pages?
yeah, it's right here on the slide.
Oh, okay. Thank you.
You're welcome. You know, we have the disclosed dual agency agreements. There's remember, there's also 4 types. There's one for a buyer, one for a seller, one for a tenant, and one for a landlord. The book only has the one on page 47. It's an example, I think, of the seller's disclosed dual agency agreement. And then there's no actual formal name for a contract. Some people, they start getting, well, I like to call it a sales contract, and I like to call it a buyer's contract, you know, and they get all high and mighty, and it has to be called what I say it is, because that's what I'm used to, and that's the way I like to call it. Well, don't be so high and mighty, because there's no official name for the contract. As you can see, it goes by many names. Where can you see that? if we skip the contract here, we go to page 187. There's no official name for the contract. Okay, this is here on page 187. There's no official name for the contract. Let's see what it goes by a lot of different names. Some people call it an offer to purchase, a contract of purchase and sale, an earnest money agreement, a binder and deposit receipt, purchase contract, sales contract. There's many things that it could go by. Okay, there's no official name. That's all they're saying. All right. Now, offer and acceptance. Wait, offer acceptance, meeting of the minds. Isn't that one of the essential elements of a valid contract?
Yes.
So let's see how that offer and acceptance process works in real estate contracts, shall we? Now, I have a note here. I'm gonna read this whole process to you, but I have a basic note here that you need to know for exams. Offer and acceptance is when the parties are in agreement on all the terms of the contract, right? So in contract negotiation, an offer is accepted once the person who made the last offer has been notified of the acceptance by their agent. That could be verbally. Doesn't have to be in writing. That's in contract negotiations. So delivery, acceptance, and signatures are not required for an offer to be considered accepted. But it's always recommended that you follow up with getting it in writing and signed, right? So you write up the initial contract, and then we go back and forth and negotiate the terms. So then we're gonna have to make changes to that contract, have the parties sign off on the contracts. That's always a good, it's always a good practice to do that so that we have it in writing what the parties have actually agreed to, and before we send it off to the attorneys. But technically, for exam purposes, in contract negotiations, when is the offer considered accepted? Simply when the last party who made the offer's agent has been notified. Because anytime the agent's been notified, it's as if the client themselves has been notified. Because we have a fiduciary duty. Remember our fiduciary duty of disclosure? To run back to our clients and disclose to them any information that we learn. Okay. So let's read how offer and acceptance works in real estate transactions. Okay. That process written down here. Yep. Oh, I have it here on the next slide. So before we actually go over that whole offer and acceptance deal there, earnest money deposits. Nope. I'll go back and forth. So let's see. So on this slide right here, offer and acceptance, how does this work? So one of the essential elements of a valid contract is a meeting of the minds where the parties to the contract are aware and in agreement on all the terms of the contract. This is done by the process of offer and acceptance. So this is how it works. First, the seller lists their property for sale at a certain price. The buyer makes an offer at that full listing price, or maybe another amount, which their broker then presents to the seller or their agent, through their agent. The seller then accepts the offer, rejects it, or they make a counter offer. What is a counter offer? A counter offer is basically a rejection of the buyer's initial offer. So at this point, the buyer's free to walk away if that happens. They don't have to do anything else. Their offer's been rejected. That's what a counter offer is. So a counter offer is when the seller rejects your offer and they make another offer back to you. But in essence, didn't they just reject the offer that you made? So you're free to go. You don't even have to respond to anything else. Now, if the seller does make a counter offer, the buyer can either accept it, reject it, or make another counter offer. They could go back and forth like this until one of the parties agrees to the other's terms. And when they do, this is called a meeting of the minds. They finally come to a meeting of the minds on all the terms of the contract, right? And then the contract is considered, the offer is considered accepted pending attorney review. But it's still not a legally binding contract until attorney review is concluded. So I have it written here again. In contract negotiations, when is an offer considered accepted? When the person who made an offer has simply been notified that their offer has been accepted. This can be done verbally. However, it is suggested and a good practice to always follow up with getting it in writing, but it's not required.
Victor, I have a question.
Yes.
What if you're doing a sale and you don't have attorney review period? Like, let's say neither one of them want to do an attorney. Then it's just cut and dry.
Yeah, then we wait the 3 days and then the contract is binding the way it is.
And the
But
three,
but you better make sure you had them sign that opinion 26 notice so that they don't say later on, oh, you never told me I could have an attorney.
no, I understand that. But let's just say in that cases, both people waive the right to have an attorney. And then so they're countering with each other. And then once it's accepted, then we're good.
Yeah, we could do the negotiations with, that's what we do. You know, we usually do negotiations, but if you have them, if you're doing negotiations like that, you do that with the term sheet, not by writing the actual contract. Okay.
Okay.
All right. Now, no. Let me back up that slide. Offer and acceptance. Let me just write this is fully explained on the next slide. See next slide. All right, so the earnest money deposit, that is the good faith deposits. Okay, so let's see, offer and acceptance, we read that. And on page 188, we're going to highlight an offer is not considered accepted until the person making the offer has been notified of the other party's acceptance. And then also underline notified of the other party's acceptance. And you may want to write above that, delivery and acceptance or signatures are not required, but recommended. Just like it's written here. Delivery, acceptance, and signatures are not required, but recommended. When is the offer considered accepted? Simply upon notification. Right? Okay. Delivery, acceptance, and signatures are not required, but recommended. Let me know when you guys got that all written down. Everybody get that yet?
Yes.
All right. So an earnest money is also referred to as a good faith deposit. It's customary for a buyer, when making an offer on a property, to accompany it by a minimum $1,000 good faith deposit along with their offer to show their intention is good, to show that they are intending to carry out that contract and carry through with it, that showing that they're operating in good faith, that they want the seller to accept their offer and take their property off the market, and that they intend to follow through with that transaction. So it's customary to include a $1,000 good faith deposit with any offer to show the buyer's good and serious intent to proceed with the purchase. The contract, however, is still valid if no good faith deposit was made. So is a good faith deposit required?
No.
No. The offer is still valid even if no good faith deposit was made. Try that on one of my listings, though. I'm going to advise my client, something's fishy here, don't accept it. Not unless they agree to, not unless they're doing like digital contracts, sending it over for digital signatures. And well, even in that case, they should have some kind of good faith deposit on file with their broker. But if they don't, then they need to follow up like right away, like in a day or two with that money. They got to have some kind of good faith deposit. Otherwise, I'm going to ask the seller who I'm representing not to take their property off their market to accept this offer unless they put down a minimum of $1,000 good faith deposit. Sometimes you get buyers, they'll be like, okay, well, we'll put $50 down or something like that. I'm like, what's up with that? You get your money back if the deal falls through. Do you not have $1,000? You're going to need more than $1,000 to purchase real estate, you know. So
Where would you put the good faith deposit in the contract, like letting them know?
we will go over that when we actually go over the contract, but it's right under where they put the purchase price. Okay. Here's the first page of the contract. Total purchase price in this example is $300,000. And then an additional deposit. That's your $1,000 good faith deposit here. And if you see on the next page of the contract, it says the initial deposit. That's your good faith deposit. Who was it paid to? Who's holding on to that money? In this case, if you're the buyer's agent who's preparing this contract, because buyer's agents are the one who prepares the contract, we would turn that money over to our brokers immediately, right? And the broker puts it in their escrow account. When did they do that? Just write that date here. Whoever's holding the deposit money, you would write that. All right. And then you'd write down their escrow account. Who's holding the money? You'd write down the name of your company here. If it's an attorney that's holding it, do not write the attorney's name here, because their trust account could be in the law firm's name. You need to find out. Okay. So the offer, if the offer is rejected, the money is immediately returned to the would-be buyer. If the offer is accepted, but the transaction falls apart, the seller has to agree to release the funds before the buyer's broker can return the money back to the buyer. There's always a possibility that they may make claims against it, that they want to keep some of that money. And if they do, I'm sure the buyer's not going to just agree to it. So we as the brokers cannot just release the funds back to the buyer, even though it's their money. Both sides have to agree to where that money is going to get released to, whether it's going to be for closing or whether it's because the deal fell apart. Okay. Now, if the offer was never accepted to begin with, the money goes back to the buyer. But if the offer was accepted and the deal falls apart for whatever reason, we don't know. The seller could be making some sort of a claim that the buyer wasn't operating in good faith and they want to keep some of the money or all of it. If that's the case, can we release the money to anybody if the buyer doesn't agree to it?
No.
We would have to hold on to that money and only release it if both parties agree. If both parties can't agree on it, who would make that decision?
Court.
The judge. That's right. So then we can only release those funds to a judge, to the court, or if we have a letter from both parties to agree to release the funds back to the buyer.
Right.
So highlight under earnest money deposits on page 188, on the second line at the end of the line. Earnest money or good faith deposit gives evidence of the buyer's intention to carry out the terms of the contract.
Where is this?
On page 188, under earnest money deposits on the end of the second line. Earnest money or good faith deposit gives evidence of the buyer's intention to carry out the terms of the contract. Then in the next paragraph, in the last sentence, we're going to highlight contracts provide that the deposit becomes the seller's property if the buyer defaults as liquidated damages. Now, I want you to write a little note in the margin there next to that with a little arrow pointing to that highlighted line that says only if wording was added to the contract that says this. Only if wording is added to the contract that says this. All right, sorry about that. Okay, so the next paragraph we're going to highlight. Earnest money must be deposited by a broker within 5 days in a special trust or escrow account. This money cannot be commingled or mixed with the broker's personal funds. This is an illegal act known as conversion. Right. Pretty much just remove this stuff from the slide then. Make life a whole lot easier. You guys highlight that? So basically it's the same thing we highlighted in chapter 3. That in chapter 3, it says, when do we gotta, any money our clients give us, when do we gotta give it to our broker?
5 days.
No, immediately.
Oh, immediately, sorry. They have to do the deposit 5 days.
They have to deposit it into the escrow account within 5 days, correct, right. Sorry guys, I'm just making some adjustments here to the slide. All right. All right, sorry, just made a little tweaking to the slides a little bit. All right, so the yes, as you guys can see, earnest money deposit has to be given, also referred to as the good faith deposit. If the money is, if the offer is rejected, the money gets immediately returned to the buyer. Offers are still valid even if it's not accompanied by $1,000 good faith deposit. The buyer's basically asking the seller to take their property off the market. Let's see, if the buyer breaches the contract, the seller could claim, make claims to keep the money, but both parties would have to agree to that. If they don't, only a judge can decide who gets that money unless both parties agree about who gets it. Okay. Brokers must deposit the money into the escrow account used only for keeping clients' money for short periods of time. It must be deposited within 5 business days from the time the client gave their agent the money, not from the time the offer is accepted. So we do not hold on to that money. We must turn it over to our brokers immediately. Okay. And if our client gives us $10,000 or more, what do we got to do?
Notify the IRS.
That's right. We got to report it to the IRS, and that's not on the next slide. It was in the previous chapter. So let me see. Let's also make that note in here. We'll squeeze some of this stuff in together. Yeah, we credit towards the buyer's purchase. Okay. And yeah, any cash deposit of $10,000 or more must be reported to the IRS. Okay. That is an exam question, so it's only fair to put it there. Put it out there. Yeah. All right. So let's highlight that. Any cash deposit 10,000 or more must be reported to the IRS. All right. Signatures. All right, so the meeting of the minds, once again, is when all the parties are in agreement on all the terms of the contract, all the details of the contract, right? School exam focuses on the financial aspects of that. So when the parties are in agreement on price, down payment, and financing method. So how you coming up with the rest of the payment, the rest of the cash, right? Cash, mortgage loan, etc. Kickback. What is a kickback? It's giving anything of value to a friend in exchange for here's an example. Giving anything of value to a friend in exchange for a lead, or any unlicensed person, or money back to the seller. Sellers cannot get rebates. So giving anything of value to a friend in exchange for a lead, or or any unlicensed person, including a seller, and then we just got that little note there that sellers cannot get rebates. You want to give anything of value back to the seller, charge them less commission to begin with, right? Rebates in some states to sellers are legal, but they are not legal in New Jersey, okay? However, we can give the buyer of a primary residence rebate, right? Buyers of a primary residence can receive rebates legally. Therefore, that is not considered a kickback. Okay, so what's a kickback? Giving anything of value to anybody without a license, basically. Right? Now, if you're going to give closing gifts to buyers, you should limit the value to 35 bucks, you know. This way, that could be in no way interpreted as being a kickback. But once you start buying somebody, you know, expensive shoes or pocketbooks or trench coats or those expensive gaudy watches or any kinds of other expensive item, that can be construed as a kickback. And something is wrong in that transaction. You know, some agents like to give buyers closing gifts like a bottle of wine. But bottles of wine, that just gives you a headache. You drink it, and now you got a headache and you forget all about the agents. So I like to give closing gifts that keep on giving, you know, that give me leads that also are tax deductible then, because it's a business expense that I used. So yeah, let me give you some examples of closing gifts. Would you want that? Would you? No? Okay. Whatever.
Sure.
No skin off my back.
Victor, you could give
A Home Depot card.
No. No. Anything you give them of value has to be, you know, you got to keep that price down, you know. I wouldn't give it, I mean, what are they going to get with a Home Depot card? A couple screws, you know? I mean, you could give them a nice closing gift.
Give wine.
Wine, you give them a headache, and then they forget all about you. How about this? You know, there's some things that you could give. I don't have the links to those gifts, but there's like these custom carving boards that you could give them that you engrave, that their name is engraved in it, or the carving board is shaped with their family name engraved in it, or burnt in it. And then on the other side, or the other side of the either the complete other side or just the other edge, has the real estate agent's information on it. You should probably have yours on the back there so they don't got to look at it all the time, but it'll be there if they need it. Here's something from Reminder Media, a company called Reminder Media. How about you give them you put them on a subscription of getting custom real estate magazines with your picture, your company logo, and your contact information on it, and put them on like a 3, 5, or 7-year subscription of this, that they'll get this quarterly. It's kind of like it looks like it's your own custom Better Homes and Garden magazine that's coming from you, that you publish. Except they got professional photography, professional writers that create these magazines. All they do is they stick your picture and contact info on it. The gift that keeps on giving and keeps you in front of them. I've had clients that I've sold houses to, and years later, they reached out to me and they said, yeah, that magazine you're sending me, it stopped coming. Can you put me back on that list? I like that magazine. Yeah. Oh yeah, sure. What's your name? So how's it going? How's the house doing? You know? Since I got you on the line, as you know, our business deals mostly with referrals. So I'm sure you're glad and happy with the business that I've done for you. Out of everybody you know, who do you think would be next to make a move? And would you introduce me to them? Would you tell them about me first? Okay. You're trying to ask for referrals. If you've been in the business for a while, follow up with your past clients is a good way to get referral business. Hell, your past clients may be getting ready to move again. Or maybe they got other family members or friends or coworkers or somebody that they know that's looking to move, buy, sell, rent, what have you, right? So ask them. This is a good way to keep in touch with them too, so that they don't forget your information. NAR does a lot of statistics and studies and follow-ups for closings from agents. And one question they asked a lot of people was, were you satisfied with the business, the services that your realtor provided for you? And the majority of people say yes. And they say, would you use them again in a real estate transaction? They said yes. Have you done another real estate transaction since you purchased this home with them? Yes. Did you use the same agents? No. Why not? Forgot their name, forgot their number. They didn't keep in touch with me. Isn't this a good way to keep in touch? Stay in front of them. And it's kind of like you put it on a set it and forget it program. It's a pretty cool thing to do. All right, and they have all these different, the Lifestyle magazine, they have a digital marketing bundle now, which I don't know what that's about. I haven't revisited this site in a while. You got to look here and see what the prices are, but they're, last I checked, they're affordable, but you could set them up on multi-year programs or what have you. Let's just see what their products are for American Lifestyle magazine itself. So this is from Reminder Media, guys. Okay, remindermedia.com. Yeah. So your very own professional publication. Here, let's watch their video. I'm not selling their product or anything, by the way. Just it's a good thing. So why not tell you about it? If it ever loads. Come on. Look at that, customized with your information. Really, that was it? All right, well, anyway, that's a lot of hoopla for nothing. But it's a way to follow up your clients. They get these professional photography, professional articles, it's all customized with your photos on the front or in back, And here's some testimonials from people. All right, anyway, you could go to their website to find out more info about it. That's remindermedia.com. On our website, we're redoing our website. So I'm gonna be putting up a section that has a bunch of other resources for agents for closing gifts and all kinds of other ideas like that as well. Which, by the way, let me give you another resource. I had an attorney, just let me stop this share with you guys for a minute. I had an attorney attorney's office that called me today to follow up that I've done business with before in the past. I didn't use them and refer them to the client. The client used them, and then I used them on a couple of other transactions. People seem to be happy with them. They're inexpensive, and they got some kind of promotion that's going on now for people who are using buying or selling real estate. That they have a cheap. They charge a small amount of money. Hold on a second here. Let me open up this email that they sent me, and I'll share that with you once I open the email here. I don't want to share with you guys all my emails, so let me share with you this. Okay. So here's from this this law office. So they got some kind of winter special going on for $425 for single family closings. Okay, which is pretty good. And I spoke to this lady. She's a secretary at the office, or a paralegal. And they're just following up with their past clients, letting us know about this. But she also told me, because I told her that I also have the real estate school. She told me that they have also this realtor referral program going on, where they deal with this mortgage company that they partnered up with to do like sales and referrals of business back and forth to each other. And as part of that, they said that if you refer, you do referrals and business, with this mortgage company too, that they have a program, the mortgage company, they'll pay for some of your advertising. You want to put an ad in a magazine or something, do some co-marketing, send out postcards. Okay. So I don't know. This is from the Kaplan Law Office. Here's this lady's information. 2300. Where you can give me a call, get more info. Okay, so I don't know. She gave this one number here, the realtor promotion and all that. You guys want here? I'm just gonna copy and paste this $425 winter special thing for you guys, sale or purchase. So you guys have this information. Sometimes you have clients. Your broker may have have some of this attorneys already on that they've used in the past. But you guys are going to start working with different attorneys too. And if they do good by your clients, you know what? Refer them business. As long as they're doing good by your clients, right? Here, I'm giving you all their information here, okay? There you go. Boom. I sent it to everybody there in that text message that they could copy and paste and save for themselves. All right. Their website there is njrealtylaw.com. All right. I'm just passing it along. I just spoke to him today. This is an email I got today, so why the hell not, right? Just sharing the love. So
Thank you.
if hey, if they're you guys should do that for any mortgage company that you deal with. You should ask them for business. Don't just give them business. Ask them to help pay for some of your marketing, because it costs you money to get those buyers and sellers, right? So if they make money off of you, why don't you ask them to help kick in and do some co-marketing? If those agents won't, at least maybe their broker, their company will, their brokerage or their bank will, right? If not, screw them. All right. Just throwing that out there for you guys. All right. So let's highlight. Well, let's first go over this. Here's parts of the sales contract. You got to have the contract has to be in writing. You got to have competent parties. The agreement has to be to buy and sell. Adequate description of the property. The consideration must be stated. The full purchase price, legal tender, exchange of value, love and affection. That's if it's a gift. The grantor agreement to convey. The grantor is the seller. The place and time of closing has to be listed in the contract. The signatures of the parties with their initials on every page has to be on that contract as well. Here are some of the non-essential parts of a valid contract. Encumbrances to which the deed will be made subject to, because not all contracts have encumbrances. Not all properties have encumbrances. That's why. But they should be stated if they do. Earnest money deposit, the good faith deposit. Well, is it required to make a contract valid? No, it is not. Mortgage, although you should always you guys should just ask your clients. Don't give them an option. How much do you want to put down? say, you guys have to put down a minimum of $1,000 good faith deposit. You know, the deposit should be large enough, sufficient enough to show that you have a serious intent to go through with the this purchase. And it also makes your offer seem stronger. Yeah, you're giving me more negotiation stance the bigger that deposit is. The mortgage financing, the buyer's going to plan to use. That doesn't need to be in the contracts. But look, all of our standard sales contracts has it in there. The date of possession by the buyer, type of title evidence, prorations and adjustments, all that stuff isn't usually put in the sales contract. Doesn't need to be. That's what the attorneys do, or title company. We do have this in our contracts to talk about what if the property gets destroyed during the contract term of the contract. What if either party defaults? What happens? Well, you could always put in there some sort of liquidated damages agreement, right? You could write in a final walkthrough thing, but you don't need to. You can still do the final walkthrough. It doesn't need to be written into the contract. And when do we do that final walkthrough?
Yeah, closing.
The day of the closing. You don't want your clients to close on the property and then go to it and find out the kitchen's gone, right? Remember that story? Contingency is a happening upon which contract's dependent on or subject to. We spoke about a couple examples, but we're going to talk about a couple more. But contingencies do not have to be in the contract because you may not have any. But if you do, you should put them in the contract. And signatures of witnesses are not required for a contract to be valid. Let's actually highlight that on page 189. Under the last bullet point there, highlight the signature of a witness is not essential for a valid contract.
Where is it at?
On page 189, underneath the bulleted list.
Okay.
See, these are non-essential parts of a valid contract. They're usually included, but they're not required to be. Okay. Now, the sales contract, we already went over this. There's no official name for it. It goes by many names. Okay, so contingencies. What is a contingency? It's a happening in which the contract is dependent upon. Or we could say it's subject to. This purchase is subject to, could be many things. These are the get out of contract free cards. However, when you guys are preparing a contract, it should be as contingency free as possible. A contract with no contingencies is much stronger than one that's loaded with them. Would you agree? Because a contingency is a way for a buyer to get out of the deal. Which one would you accept if you were a seller? One with a lot of contingencies or one with few? You there? All right. You would want to submit the contract as contingency free as possible. All right. And if there are contingencies in the contract, our job as agents are to remove those contingencies as soon as possible. So here are some common contingencies that we see in sales contracts. That the purchase is subject to the buyer being able to get the loan. And look, if they're getting an FHA or VA loan, we're required by law to put a special contingency clause in all contracts where the FHA and VA is providing the loan. So if the property does not appraise for the purchase price, this is what it states, the special contingency clause. It says that if the property does not appraise for the purchase price, that the buyer can get out of the contract without penalty. So what's the purpose of the special contingency clause that's required for all FHA and VA loans?
Repeat the question.
What is the purpose of the special contingency clause that's required for all FHA and VA loans?
Oh, if it doesn't, well, it says it right there. The property does not appraise for the purchase price, the buyer can get out of the contract without penalty.
Yeah. Now, I know it says it there, but a lot of people aren't paying attention, so I just want to make sure that they are. So I ask you questions about what I just explained.
The liquidated damages?
Huh?
And the penalty would be the liquidated damages?
Without penalty.
No, I know, but I'm saying if they didn't, if that wasn't the case and they were to get a penalty, the penalty is the liquidated damages, right?
Well, liquidated damages is an agreement that if one of the parties breaks the terms of the contract without a good legal excuse, they breach the contract. It's just an agreement on how much would serve as compensation. The special contingency clause, however, is required to be added in only if the financing is coming through an FHA or VA loan. It basically says that if the contract doesn't appraise for the purchase price, then the buyer can get out of the contract and there will be no penalty. In other words, you can't hold them in breach of contract because they don't go through with the purchase because an appraiser says that the home does not appraise for the purchase price. This is their reason to get out of the contract without penalty.
Right. So my question is, if they don't have this clause, I'm just saying, like, if
Then they would be in breach of contract.
I'm just trying to figure out what type of penalties would they have if a buyer just
The seller can sue them. The seller can sue them for breaching the contract. Or if they did have a liquidated damage agreement in place, well, then the money would have been stated in advance what the penalty would have been. But it doesn't matter. FHA, VA loans, if that's where it's coming from, the seller don't have a choice. If the financing the buyer's using, if they agree to allow the FHA or VA loan, the seller can't say, oh, you can't add a special contingency clause in later. And federal law requires it. Okay. And this will usually be added in, sometimes during attorney review, but we don't need to do that. We don't have to wait till attorney review. If we know that it's going to be the financing is coming through the FHA or VA, we can get that, we can print out the special contingency clause from our contract form system online. You guys can go to njrforms.com and that'll take you to the real estate contract form system that we use. I think I've showed it to you before, but I think it's at a link at the end of these. Here we go. At the end of this slideshow here, we got this. I put a bunch of links here for you, resources, things that you need to prepare for the sales contract and what to fill in some areas, okay? Mortgage commitment letter to be produced 30 to 45 days from date of contract, business day date if put on contract, closing date should be 45 to 60 days. Make sure it lands on a business day from date of contract, okay? We have to put real estate licensees' names and number and their license numbers. Where do we get that from? We go to the here's a shortcut URL I made to the Real Estate Commission's website where you can look up the license numbers. You're going to print out the tax, the listing from the MLS and make that part of the sales contract. You can look up the tax records. Most MLSs have a tax record system there that you could just click on it and it'll pull up the tax info from the property when you're logged in. But I got this shortcut here to the tax record system. Okay. I made this shortcut NJR forms to this longer URL, which is the contract form systems from NJ Realtors. Part of your dues, you get this, as part of your dues, it's no additional fee. So might as well take advantage of it, right? Anyway. So contingencies, here's some more contingencies. Contingent upon a home inspection by a New Jersey licensed home inspector, not your cousin Vincenzo that knows a thing or two about construction, All right, you got to get a New Jersey licensed home inspector. If you want that purchase to be contingent upon a home inspection, it can't be done by somebody who just knows some stuff about construction because they used to work in construction or whatever. You got to get a New Jersey licensed home inspector to prepare a report. Otherwise, attorneys aren't even going to consider it for negotiations of for work to be done or repairs. We have a mortgage contingency clause that's added into contracts. It basically says that what type of loan, and if the person can't get the loan, they cannot be held. It basically, if the property is not appraised for the purchase price, the buyer can get out of the contract without penalty. Okay. An approval by family member who may be helping out with financing or the down payment. We want to get all those family members to go through that house before we write the contract. We don't want to put a contract together and say, well, now we got 9 other people who are helping out with the money to buy the house, so we got to write down all their names there. And if any of them say no, then they could get out of the contract without penalty. A seller's going to be like, are you kidding me? They're not going to accept that offer, you know? So try to get all those family members through that house, all right? So sometimes family members are, you know, maybe you get the parents that are helping with the money to buy the house, if that's the case, or giving them down payment, but they want to look at the house first and give their approval before they give the money to help them, right? And look, in some cultures, I find it a lot with Indian culture, with a lot of the Indian families, they tend to work as a pretty close unit where they tend to support each other a little bit more, where you see even extended family members that help them with money for the down payment, closing costs, or the purchase price altogether. But all the family members, you know, need to take a look at the house and give their approval before they give you that money. And listen, I've had 3 carloads of family members before that had to give their approval. Now, I'm not writing down 3 carloads of names, of long names that I'm not, foreign names that I couldn't figure out how to spell. They're not in my vocabulary, you know, and write them on contracts as contingencies. I'm going to try to get all them family members through that property first to give their approval, and then I don't have to write them down as a contingency in the contract. Then let's see. The purchase is subject to the sale of the buyer's current home. Maybe the buyer already has a home to sell. Now, if you're going to write that as a contingency in the purchase contract, at least write down, is it even on the market? Is it under contract? What's the status of that property, right? That's very important. That's your job, guys. You need to find out if that buyer, where they live now. Are they living at home with their parents and they have no leases or homes that they need to sell for first? Is there a lease that they need to get out of? Can they get out of it? If not, you got to put that down here as a contingency. Now, if the seller agrees to accept your offer contingent upon the sale of the buyer's current home, sometimes the seller or their agent will ask the buyer to add what we call an escape, kick out, or knockout clause. Okay, this is usually on the contract, by the way. What is an escape clause? Who does an escape clause protect? It protects the seller. So what does it do? Well, when a buyer makes an offer that's contingent upon the sale of the buyer's current home, if the seller accepts that offer, they could say, hey, listen, I want you to add an escape clause to that contract. And it basically says that we'll accept your offer that's contingent upon the sale of your current home, but only if you allow us to continue marketing our home for sale. We'll accept your offer, but we're going to continue marketing our home for sale. And in the event that we get another buyer who puts an offer in writing that is acceptable to us, we're first going to come back to you and ask you if you're ready to remove that contingency yet. And if you're not, we could cancel the contract with you to accept this other offer that we have in writing. And we won't be in breach of contract with you. That's what an escape clause does. So you guys see how it escapes, the escape, kick out, or knockout clause protects the seller?
Yeah.
Okay. You will get something about that. I forget if they refer to it as a kick out or escape clause on the contract. All right. Yeah, you could state this could be a contingency, the expiration of the buyer's lease. Maybe the landlord won't let them out of the lease early. So let's not do the closing for another 2 months or whatever until the my lease expires. Maybe a use permit. The purchase is contingent. Remember I told you builders often do this? The purchase is contingent upon us getting the permit to build whatever we want to build on the property, or to get a permit to use the property for a commercial purpose that we want, or, you know, because it's not just residential real estate, you know, commercial as well. So contracts can contain contingencies. We just don't prepare the commercial contracts, okay? Building contingent upon getting a building permit for construction, or contingent upon third-party approval. For example, if it's a short sale or bankruptcy, or I don't know, divorce, you know, whatever it is, we would have to put all those are all contingency clause. So the sale is subject to these things. Okay.
And Victor, these are all things that you would put in the sales contract.
No, these are all things that you could put in
Right,
the contract. Yes. Yes. And where would you put them? You would put them, here's the sales contract. Let me scroll through to all the way to the end of the contract. You guys see the contract right now?
Mm-hmm.
Okay.
Yes.
So when you get all the way to the end of the contract, there's an area for any addenda that you're going to be adding. Addenda are any add-on documents that you already have typed up. Or if you're going to be writing anything into the contract, additional provisions, if any, you would write them here. So here's where you would write down, you know, subject to the sale of the buyer's current home at 123 Main Street, which is currently listed in whatever MLS, and here's the MLS number. It's currently under contract, pending closing on such a date. You know, I would put something like that.
And that's where you could put like liquidated damages, contingency clause.
Well, the seller would be the one that insisting on a liquidated damage thing, but yes.
Okay.
But yes, that's where you would write it. Or look, at the end of the slideshow, I give you a couple examples of other contract contingencies that you could write in here. I give you some examples of how to write them, like this. A seller's concession. A seller's concession is you're asking the seller to give up money to the buyer towards their closing costs, pay the buyer's closing costs, or maybe money for repairs. But keep in mind, the maximum seller concession allowed for an FHA loan is 6%, and the maximum for a conventional is 3%. So see, I give you examples of how you would word it. You would write buyers requesting a seller's concession of up to 3% towards the buyer's closing costs and prepaids. This is a concession, not a loan. Here's a simple, short way to say that this is a short sale, and the purchase price and commission is subject to third-party approval. If you're going to state that the buyer is responsible for obtaining the CO and fire inspection certificates, I would only add this in if the seller specifies that they're not going to. All right. Otherwise, the seller should be paying for that. Here's an example home buyer contingency clause. That's how I would write it in here. Or if the approval's subject to the relatives contributing, you know, you would write something in there pertaining to that. All right, so we finished this contingencies. Okay, contract contingencies could be FHA loans subject to engineering reports, escape clauses, liquidated damages, short sales subject to family members' approvals can be added in. These are some additional ones. Okay, you don't really need to know this for exam anymore. Okay, rescission of a contract. What are the different ways that a buyer can get out of the contract? What's the rescission period after they submit this offer in writing? When can they get out of the contract? If it's a resale property, how long do they have to get out of the contract? Hello? Buyer makes an offer. Seller accepts it. How long does the buyer have to get out of the contract?
3 days.
The attorney review period, 3 days. What if it's new construction for the discovery of off-site conditions?
Oh.
7.
Here,
That-
I put it here on another slide in this chapter again too. 5 days. For out-of-state properties marketed to New Jersey residents, 7 days, and for large in-state subdivisions, 7 days as well. For the purpose of canceling mortgage contracts, financing contracts, not purchase contracts, mortgage contracts. There's a 3-day rescission period for refinancing, but there's no rescission period for purchase money mortgages. That's any mortgage loan used to buy real estate. Okay, you can remember, just read that backwards. Purchase money mortgage, mortgage money to purchase. Any loan used to buy real estate. Okay, option agreements must be prepared by attorneys. They're unilateral. And land contracts, we didn't go over that just yet. So let's do some highlighting and get that done. All right. So under contingencies, page 189. Contingencies, page 189. Everybody there?
Yes.
Yep.
We only got 10 minutes to get through a couple more things. I want to finish this chapter up. When the purchaser intends to secure an FHA or VA loan, special clauses must be included in the sales contract that provide the contract may be voided if the property appraises below the sales price. That's the purpose of that special FHA, VA special contingency clause. Next paragraph, we're just going to highlight the term subject to on the first line. It's a very powerful phrase. It's a happening of which the contract is dependent upon. In that same paragraph, go down 1, 2, 3, 4, 5, 6 line. See the line that has the word contingency in bold? The next sentence highlight where the purchaser has another home that must be sold first. The seller may insist on an escape clause, also known as a kick-out or knockout clause. Then I want you to write in the margin there, protects the seller. And then you guys already have liquidated damages highlighted, right?
Yes.
Okay, turn the page. Under rescission of a contract, second paragraph, highlight it. Borrowers who change their minds about mortgage loans have 3 days to cancel the contract, but there's no similar right of rescission that applies to loans used to purchase real estate. And then right beneath that, purchase money mortgages. Purchase money mortgages. All right. Option agreements. Highlight the title, option agreements. And then on the last line, just highlight should be prepared by attorneys. And then here's one more new thing, the last thing, a land contract. What is a land contract? Here, I got a slide that fully explains this nicely for you. But let's highlight in a book what we need to highlight first, and I'll explain it. Highlight the title, land contract, and then highlight land contract, sometimes called an installment sales contract. Land contracts are typically used as a means of seller financing. Then go down a couple lines. You see where it says equitable title in bold?
Yes.
The line just above that, just above where it says equitable title, as a matter of fact, highlight, although the buyer obtains possession when the contract is signed by both parties and the buyer has equitable title, the seller does not execute and deliver a deed to the buyer until the terms of the contract have been satisfied. All right. Now look at my slide here. You're should snap a picture of this. Land contracts. Do not confuse it with a ground lease, which you're going to learn about in the next chapter. A ground lease is when you lease land and construct, it's a long-term lease of land, and then you're going to construct a building on someone's property. That's a ground lease.
The sales contract where you have additional contractual provisions.
I'm sorry. I was bouncing around a little bit and you guys weren't even seeing that. All right. So land contract. So do not confuse it with a ground lease. You guys can see it now?
Yes.
Okay. It's a type of seller financing, also known as an installment sales contract. It's basically a lease to own. The buyer makes their payments in installments and they wait for the deed because the seller does not give them the deed until the buyer pays off the full amount or an amount that they agreed upon. Until they pay that amount off, then the seller will give them the deed. So until the buyer pays off the full amount owed, they don't get the ownership. However, they do have an ownership interest through those payments that they've been making to the seller. This is called equitable title. Even though they don't own the real estate yet, they do have a financial interest towards the ownership. Okay. So what is a land contract? It's a type of seller financing. See, seller financing, here, let me just explain what regular seller financing is. Seller financing is, instead of going to the bank to get a loan to purchase the real estate, you're just going to make your mortgage payments to the seller. And the seller's going to sign the deed over to you at the closing table, just like they normally would. And then you're going to be making the monthly mortgage payments to the seller instead of a bank or a lender. That's not what this is. This is a different type of seller financing. A land contract is kind of like a rent to own, where the seller's not going to, you're going to be making monthly mortgage payments to the seller, but the seller's not going to give you the deed until you pay off everything that you owe them. So what happens if you stop making the mortgage payments to the seller?
It's like a layaway.
Well, because they didn't give you the deed, you're not the owner yet. So they don't have to foreclose on you and go through that long, expensive, tedious process. However, you're not quite a renter either. You're more than a renter, but less than an owner. You're in between, right? So if you have a land contract, they don't have to foreclose on you to get you out. But they can't take you to landlord-tenant court to get you out either, because you have a financial interest that you've been paying towards the ownership of that property. It's a little bit more complicated to get you out than a renter. Now, what happens if you don't make those mortgage payments? Do you get any money back, or what happens? You guys got a million questions about this. I got no answers. The reason being is these contracts are custom. It depends on how the attorneys drew them up. I have no answers to you to tell you how they work. Everyone is custom agreement. Okay. Now, the term equitable title, what does title mean?
Ownership.
Ownership. And we know there's no document in real estate called title. We transfer ownership by deed, right?
Right.
So equitable title. I got a definition for equity. Let's look at the root word of equitable. Equity. Equity is the difference between the market value of the property and what is owed on it. It's built-in value. When you first buy your property, your equity is equal to your down payment.
Right.
Now, there's ways that you could increase your equity in your property. If you just wait until the property values go up, your equity can rise. Or you can make mortgage payments paying down the debt. Aren't you building equity there too?
Yes.
Or you could do improvements on the house, forcing the value to rise, further increasing the equity. See, so there's 3 ways that you could increase equity in the property that you own. All right, so equitable title, it's the value that you have into the title, into the ownership, even though technically you're not an owner yet. That's why it's harder to get you out than a tenant, easier to get you out than an owner who's just defaulting on their debt. Because you're not an owner yet, but you do have a financial interest in the title. So equity is a financial interest in the ownership. Let's see how I just defined that. So you do need to know this for exams, though. A type of seller financing where the owner, where the buyer does not get the ownership until they pay off the full amount owed. Land contract. And what do we call that financial interest the buyer has? Equitable title. My definition is a lot easier to understand than the books. They kind of spell it out here. So snap a picture if you will, and then I'm going to click the slide. Okay, let's do the key terms to review. There are 2 of them. Yep. This shows you how to fill out the contract, which I'll do that with you guys next time I see you guys. Okay. I'll do the actual sales contract. I don't know if the other instructor has a sales contract available to her.
Can you go back so I can take a picture?
Sure. If I can find it. There you go.
Thank you.
You're welcome. All right. There's 2 key terms to review. Let's do these and then we're done for the day. All right. Key terms 1 on page 192. Are you ready?
Yes.
All right. Here we go, guys. Come on. We're in the final stretch here. Agreement between 2 parties to perform some legal act. What do we call that? Don't even look at the answer options. Think of it from the top of your head. What do you call it?
Contract.
It's a contract. There you go. 7 is A.
Your microphone's on?
What do we call it when somebody's in violation of a contract?
Breach of contract.
They're in breach. 3 is B. You see how you do that without even looking at the answers, and you can get it a lot easier. A buyer's deposit with the purchase contract. What do we call that? That buyer's deposit. They're
Earnest
submitting
money.
a contract.
Earnest money.
Earnest money.
9 is C, earnest money. There you go. See, this is how you guys should take exams too. Try to formulate the answer in your head before you even look at the answer options. 9 is C. Certain happening on which a contract depends.
Contingency.
It is a contingency. 6 is D. A contract that's not put into words, but shown by their actions rather than their words. Implied contract. I think I heard somebody say it. 15 is E, an implied contract. A contract that is set down in so many words.
Express.
Express contract. 14 is F. A contract that has been fulfilled.
Executed.
It's been
Executed
executed.
contract.
12 is G, correct. A contract that has not yet been performed.
Executory contract.
It's Tory, it's still in progress. Executory. 13 is H. A contract with a promise by each party.
Bilateral.
It is bilateral contract. 2 is I. Interest acquired by the buyer with the land contract.
Equitable title.
Equitable title.
10 is J, correct, equitable title. Offer returned to the buyer with changes by the seller.
Counter offer.
Offer.
Counter offer, 8 is K. By the way, the land contract, what is it also known as? Installment sales contract. You see it up here, guys? On the screen in front of you. Installment sales contract. That could be also be a question related to that too. Okay. Protection for the seller when the buyer has another house to sell.
Escape clause.
Escape, kick out, or knockout clause. Correct. 11 is L. Something of value that the parties give in exchange. Consideration. 5 is M. And can you tell me what the 3 forms of consideration are real quick?
Love and affection.
Love and affection. Nobody ever forgets that one. What else?
Tender.
Legal tender
In exchange of value.
and an exchange of something of value. Correct. Good, good, good. So 5 is M. Those legally qualified to enter into contracts. What do we call them?
Competent parties.
They are competent parties. Correct. 4 is N. Transfer of interest in a contract to a third party.
Assignment.
An assignment. 1 is O. Very good. And an agreement under which the buyer pays in installments and they wait for the deed.
Land contract.
Land
Land
contract.
contract.
16 is P. There you go. All right. Key terms 2. We're almost done. Almost done. Contract binding one party. The other party is free to act or not. What are they describing there?
Uni.
No.
You,
Hold on. A contract binding one party, but the other party is free to act or not. What are they describing? What does that person have?
option.
They have an option. 4 is A. I know that could be a little bit clearly written, more clearly written. 4 is A. Seemingly valid contract, but neither party can sue to force performance.
Unenforceable contract.
11 is B, unenforceable, because neither party can sue to force performance. A contract clause requiring punctual performance.
Time is of the essence.
Of the essence.
And is C, time is very important. It's of the essence. 10 is C. A return to the status quo, which means returning to the way that you started. Rescission, 6 is D, very good. A contract that does not meet all legal requirements.
Statute of Frauds.
Void contract.
It's void. It's a
Void
void contract. A contract that doesn't meet all the legal requirements is void. That is 14 is E. A contract that is binding, but one of the parties can disaffirm it.
Voidable.
Voidable. 15 is F.
Yeah.
A contract that, sorry? Okay.
No.
Contract that meets all the legal requirements.
Valid.
13 is G, valid. A court action usually asking that the seller be forced to sell as agreed.
Parole evidence rule. No. Specific performance.
It's a suit for specific performance or just specific performance. 7 is H. See, these are some of those terms that we really need to study though, that we're getting into now. Time within which one is allowed to assert their legal rights.
Statute of Limitations.
9 is I, statute of limitations. A law requiring certain contracts to be in writing.
The Statute of Fraud.
Yes, statute of frauds. 8 is J. A one-sided promise valid only if the other party acts.
Unilateral contract.
That's the unilateral contract. 12 is K. A convention that a written contract overrides spoken promises.
Is that the parole evidence? rule?
Yes, because one has evidence and one just has it verbal, right?
Right.
So the parole evidence, that's the way to try to remember it. It has the word evidence in there, you know. 5 is L. Substitution of a new contract for an existing one, or substituting an old contract with a new one. How about that? I'll word it that way.
Novation.
2 is M, novation.
Novation.
Some agreed upon to serve as damages in the case of default.
Liquidated damages.
Liquidated damage.
1 is N, liquidated damages. And meeting of the minds is also known as.
Offer and acceptance.
Offer and acceptance.
3 is O, offer and acceptance. Yes. Okay, so let me throw out the poll there for the attendance. Answer it, and you guys are done.